Commonwealth versus Timothy Alexander.
Sorry.
Good morning, Mr. Alexander. This is 23 CR 0039, Commonwealth, Kentucky versus Timothy Alexander. You are Timothy Alexander,
Yes, sir.
born in 1982.
Yes, sir.
Last four digits, social security number 5227.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason this gentleman should not be sentenced? Upon a plea of guilty to assault second degree, the defendant shall receive a sentence of 10 years, probated for 5 years to be supervised. He shall receive credit for time served, the above style case. He shall have no contact with the victim. He agrees to pay restitution to James Hayward in the amount of $2,500, the amount of $100 per month. First payment due within 30 days. It says entry of the plea, but I'm going to say 30 days from today. I don't see how you could really earn any money to make the payment today. Have you made a payment?
I'm incarcerated.
Pardon?
I'm incarcerated.
And I asked you if you made a payment. I know you.
You've not made a payment, have you? No. Okay.
Okay, well, the plea said 30 days from the day of the plea, and I know you're incarcerated, so I'm gonna give you 30 days from today to pay, okay? So you get out and earn some money. Do you understand that?
Yes, sir.
Okay, what are the court costs for this?
Court cost is 185.
185, so you'll pay $100 a month toward restitution and $30 a month toward the 185 until they're both paid in full, okay?
Yes, sir.
Mr. Stockton is correct, he'll be released today.
For this case, yes.
Yeah. So you got another case pending?
Yes, sir. He's incarcerated under a child support case, not supposed to be out till July 7th.
Okay. Well, I'll make it 30 days from July 7th if the first payments are made, the 100 and the 30. Do you need to meet with him?
Your Honor, he's already on my caseload. Just when you get released, make sure you come see me as soon as you get released.
First day, okay? Okay, thank you very much. Commonwealth versus Joseph Carter. Commonwealth versus Joseph Carter, 24 CR 0029. Are you Joseph Carter? Were you born in 1986?
Yes.
Last four digits, social security number 8914.
Yes.
You're represented by Mr. Bell, is that correct? You're here today for the purpose of arraignment. You have a right to remain silent. If you have any questions, turn and ask Mr. Bell, okay? The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance in first degree, possession of marijuana, and failure to wear a seatbelt. Mr. Bell, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, sure.
Mr. Stockton, what day is your negotiation gate going to be next month?
Mr. Bell can do this one in Monroe County on June the 7th at 9, if that's all right with him, because we're having Cumberland County in Clinton, June the 7th at 9 o'clock. So he's gonna be in Monroe anyway, so you can just do this one over there if you want to. June the 7th, well, it's Friday.
Okay, and the next court date here is June the 27th. Both of those are conditions of your bond, sir. You understand that? You have to go to the negotiation, you have to be here the next time.
So Mr. Carter needs to understand he'll need to be in Monroe County, Tompkinsville on June the 7th.
You understand? Okay, I'm signing a reciprocal discovery order. Commonwealth will give your attorney information to help you prepare for your defense. Okay, thank you very much. Guy Corbin. Guy Corbin. Are you Guy Corbin?
Yes, sir.
It's Commonwealth versus Guy Corbin, 23 CR 0055. Mr. Corbin, were you born in 1980?
Yes, sir.
Or the last four digits of your social security number?
8774.
Okay, we're here on a pretrial conference. What does the Commonwealth have to say? Okay. A motion has been filed, I've just been informed of, that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same individual that just was identified in 23 CR 00055?
Yes, sir.
Is your judgment impaired today in any way?
Yes, sir.
Okay. Have you discussed this matter with your attorney, and are you familiar with your case?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. I'm going to go down through those rights, and at the end of them, I'm going to ask if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. You have a right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. Your right to call witnesses in your favor. And have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge. You understand that by entering a guilty plea today, you give up all its rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence authorized by law. I don't have to accept the recommendation. In the event that I don't accept the recommendation and decide to impose a harsher punishment, you have the right to withdraw your plea and go to trial. Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years? Have you previously been diverted in the last 5 years? You have any felonies in the past 10 years?
Well, sir.
Are you on
Yes, sir.
probation now? Okay. You understand that if you fully complete the diversion programs, the charges will be dismissed and you can have your record expunged. You understand that? You understand if you don't complete it successfully, you'll be brought back in front of me and I could decide to avoid your pretrial diversion or a pre-sentence investigation report. You'd be a convicted felon, and that can be used against you in the future. Do you understand that?
Sir.
Counsel, would you, Ms. Anderson, Ms. Gordon Anderson, could you say what, and listen very carefully to what she says?
Yes, Your Honor. Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be unsupervised. The defendant shall make monthly payments at a rate of $185 per month on current support plus $115 on arrearages a month for a total of $300 per month. Said payments are to be paid to the Cumberland County Division of Child Support Enforcement, IBD number 5571641. First payment is to be paid on or before July the 1st, 2024, and on the first day of each month thereafter. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? Okay. Are you doing so of your own free will? Okay. Now, knowing your constitutional rights, still your desire to allow the court to proceed with your sentencing. Is that correct? Is that your signature on the document?
Yes, sir.
Mr. Bailiff, will you retrieve that, please? I'll accept the agreement, sign the pretrial diversion. You'll need to, even though you're not on probation, you'll need to check in with the probation parole officer there. Yes.
House is 15.
Court cost is $210. I'll allow you to pay that $30 a month, starting a month from now, okay, 30 days from today. In addition to the payments you've agreed to make toward the arrearage, you'll have to pay $30 for 7 months until the $210 is paid, okay? Thank you very much.
Thank you, Judge.
Yeah. Alicia Correa. Commonwealth of Kentucky versus Alicia Correa. You are Alicia Correa, born in 1984. The last four digits of your social security number are 2380. Is that
Yes, sir.
correct? Okay, you're here on arraignment on 24 CR 0025 and 24 CR 0026. Do we have those files here?
Judge, that's an error. It should be pretrial call.
it's a pretrial conference instead of an arraignment.
Yes, sir.
It had arraignment on the docket.
We've had discussions about this case, Your Honor. There's a couple of things I need to check on. If we can have one more negotiation day, we'll probably resolve this case.
Okay, when is the negotiation?
It'll
Clinton,
be June the seventh at 9 a.m. in Clinton County.
June the seventh at 9 a.m. in Clinton County is negotiation day. And what
Your Honor,
is,
I'm gonna be out of the country those 2 weeks.
Yeah.
June 1st through the 14th.
Mr. Poindexter just called me before the next court date.
when is,
Set up a
when
time
is the
for-
next Clinton County court day?
It's the 13th, but that also falls when he's out of the country, so we.
Okay, what's the July date?
I'd have to look.
I can look also.
Yeah, July is July the 11th, the motion day, and July the 5th at 9 o'clock would be the negotiation day.
July 5th.
Yes, sir.
And July the 11th, is that
Yes, sir.
correct?
Is that gonna be Clinton, or Clinton?
In Clinton.
Yeah, the negotiation has to be here, Steve.
Okay.
I'm gonna alternate each month.
Sure, no problem.
Okay, but both those are conditions of your bond, okay?
Thank you, Judge.
Thank you.
That's all I have, Deputy. Excuse.
Sure, absolutely.
Thank you.
Sarah Handy. Sarah Handy. Are you Sarah Handy?
Yes.
This is 23 CR 0044. Miss Handy, were you born in 1995?
Yeah.
Last four digits, social security number 3672. This says on the docket of pretrial diversion revocation. Is that correct?
That's correct, John.
Who represents?
He's not here. It's Bruce Brown.
He must have been a conflict attorney before she entered the plea, I guess.
And Judge, if I may,
We know, no.
I was showing them, I looked at this case on Fortnet and I was showing the same thing. I also showed that there was a motion or a notice to withdraw as counsel filed February 28th. I'm not seeing an order that he was relieved of duties, so I think he's still attorney of record at this point.
Somebody looking at file there. So let's see if it's electronically filed or. What was the conflict with your office? You remember?
It was before my time, Judge. I don't,
So you don't have any conflict?
Is it a Cumberland County case? I'm sorry.
Government.
That's a bizarre cover.
I
The
think.
motion was, what you withdraw was filed with the Commonwealth to withdraw one of their motions. It wasn't a withdraw, a motion to withdraw as counsel. Hand me the file. You found, you just found it. You found a motion to withdraw as counsel. You found a motion to withdraw as counsel. Don't find it.
And we think she may have hired Mr. Brown, because I'm not seeing.
Judge, I think that's what the case, I think it was, the DPA withdrew back sometime in
You hired Mr. Brown privately?
Yes,
Okay, where does Mr. Brown live?
in Glasgow.
This may be our office's fault, because we notified Mr. Pennington. We didn't notify Mr. Brown after he filed that notice of withdrawal.
What's the nature of the,
This is the issue, Your Honor.
Mr. Penny, you're relieved. You don't have to be up here then. Okay.
She's got 6 positive marijuana tests. She's been to a doctor in Louisville. She's never furnished any medical records. She printed off some kind of card from a website under Senate bill. Just let me
Okay, well, wait,
finish.
that's enough. I don't want to go into it anymore. You be here, on, June the 27th
Yes, sir.
with your attorney.
Okay.
And if she has valid authorization, she needs to furnish that to Ms. McCoy. If you
Right
don't,
away.
Then you need to be here.
Yeah. Right away.
Right away.
Okay.
Okay.
Yeah.
Donald Hayes,
Your Honor, not withdrawing that motion. He's caught up with restitution and he's otherwise satisfactory. Your Honor.
James Krieg. Says for review. Kriegy or Craig, or what is it? How you say that?
We had a hearing.
How you say his last name?
Krieg, I think.
Krieg, is that right?
And he's, been referred to from the specialty court, and he was accepted this morning.
I was gonna say, I think he may actually be in specialty court right now, Judge.
It'll be fine.
And I think we were.
It'll be fine. Clara Lindsay,
If they'll take.
Clara Lindsay. Commonwealth versus Clara Lindsay, 24 CR 0013. Are you Clara Lindsay?
Yes, sir.
What year were you born?
88,
Last four digits, social security number 1510.
yes.
Here today on a pretrial conference. What do you have? Who represents you?
Kevin Golf. He's here somewhere. I've already talked to him this morning.
Could you check those rooms back there to see if Mr. Goff is back there? Mr. Goff, is this your client?
It is, Your Honor.
Okay. We're here on a pretrial conference. What's the Commonwealth have to say?
Your Honor, we've not negotiated this case yet because she's not had counsel.
I sent her appearance last week or last month.
Okay, but we'll set it for a negotiation day in Clinton County,
Yes, it'll be Clinton County, June the 7th. at
June
9
the
a.m.
7th at 9 a.m.
Yes. Starts court.
And next court day here will be June the 27th. Ma'am, both of those are conditions of your bond. Okay, so you consult with your lawyer, be ready on June the 7th to be in Clinton County for negotiations and back here on June the 27th for your next pretrial.
On June 27th, Your Honor, I have a sentencing in Owensboro in federal court at 11 o'clock that morning. Might be rough for me to get there.
Well, you can't get there here unless you like have a jet or something. What?
To do this one in July because what her co-defendant, Mr. Carroll, does is going to be determinative of what happens in her case.
Okay, what will you want to still have the negotiation in June and her next court appearance in July, or you want to wait till negotiation day in
Well, we can
July?
have the negotiation because I don't know if Mr. Carroll's going to plea at that point in time too. That might save you a trip.
I'm good with whatever.
So let's have that, let's go ahead and have the negotiation day.
We'll have the negotiation day and then the next court appearance will be July the 25th here at 9 a.m.
Thank you very much, Judge.
Okay,
Can you please my business?
yeah, have a safe trip. Watch the pool water.
Okay, good. Have a good day.
Yeah. William Owsley, Commonwealth versus William Owsley. Commonwealth versus William Owsley.
And Judge, my apologies. I've been in contact with Mr. Owsley, due to be here, but Judge, this was one where we were still awaiting lab reports, so I knew we were going to be passing this, so.
Yeah, that's correct. We were going to get another date. I didn't excuse him from court, of course.
Yeah. Worried out, Your Honor, so.
So you don't know when the lab report's gonna be here?
You know about me.
Open for every day.
Yeah, I'd say set it in July, probably the best bet.
Set it for July the 25th, and you need to get word to him that he needs to be down here today.
Yes, Judge.
By 1 o'clock, or I'll issue a bench warrant.
Yes, Your Honor.
Okay, thank you.
Are you getting us on negotiation?
Johnny Riley. Commonwealth versus Johnny Riley, 24 CR 009. You are Johnny Riley,
Yes, sir.
born in 1989. Last four digits, social security number 9320. We're here for a pretrial conference. What's the Commonwealth have to say?
The co-defendant's supposed to enter a felony plea. He's on the docket next, and once he's entered that plea and sentenced, I was going to dismiss Mr. Riley's case.
Okay, well, Mr. Riley, you just have a seat back there. Hopefully, there's no change to mind here. Commonwealth versus Matthew Riley. Morning, Mr. Riley. This is 24 CR 0008, Commonwealth of Kentucky versus Matthew Riley. Mr. Riley, were you born in 1968?
Yes, sir.
Last four digits, social security number 8553. Okay, you're here for a pretrial conference. Is there a resolution in this case?
Yes, Your Honor.
Felony.
Okay. A motion has been tendered. Mr. Riley says you want to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 24 CR 0009? Okay. Is your judgment impaired today?
No.
Have you discussed these charges with your attorney?
Yes.
Are you satisfied with their advice?
So far.
Yeah. Have you reviewed the evidence Commonwealth has against you and you believe you're fully informed about your case?
Yes.
You understand you don't have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I'm gonna go over those rights with you at the end. I'll ask if you understand. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at a jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in favor, the right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove beyond reasonable doubt that you're guilty of charges against you. Understand by entering a guilty plea today, you give up those rights. You understand that? And I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I'll await a previous sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Ms. Gordon Anderson, what is the recommendation of the Commonwealth?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Okay, is that what your understanding was? Okay. You understand that if you enter this guilty plea, that it could be used against you in the future if you have any other felonies and persistent felony offender law. You understand that? Okay. Are you pleading guilty of your own free will because you are guilty of the acts as charged in the amended indictment?
Guilty.
You know, your constitutional rights have explained it to you. Is it still your desire to give up those rights by entering a plea of guilty and allowing the court to fix your punishment? Correct? You understand? Is that your signature on the document?
Yes.
Okay, I'll accept the plea agreement or pre-sentence investigation report to be done by probation and parole. And then we'll have you back here on June the 27th for your sentence. Until then, you'll remain free on bond, okay? Now, Mr. Johnny Riley can leave now, is that correct? Mr. Johnny Riley, you can leave now. Okay,
I would excuse him from court, Your Honor, and I'm going to final sentence next month. I would enroll dismissed.
okay, excuse him from court, and then once the sentencing happens, you can be, well, yeah. Johnny, you owe a $25 bond fee downstairs. If you can stop down there and pay, it'd be good, okay? Okay, thank you. Kelly Scott. Kelly Scott. What? Okay, he's downstairs getting processed.
Yeah.
Okay. Okay, we'll have him up in a minute since he's processed. Michael Scott. Michael Scott, Commonwealth versus Michael Scott, 23 CR 0048. Are you Michael Scott?
Yes, sir.
Okay, you're born in 1999.
Yep.
Last four digits, social security number 0441.
Yes,
We're on a pretrial conference. What's the Commonwealth have to say?
Have a diversion program.
Okay, I've been informed, Mr. Scott, that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person we just identified? As far as this indictment number, 23 CR 00048. Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? Are you satisfied with the advice of your attorney? Had plenty of time to discuss this matter with him. You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. I'm gonna go over those rights with you at the end. I'm gonna ask if you understand them. If you don't, you step away to the podium and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. Right to call witnesses in favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea, that you give up those, correct? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept any recommendations. In the event I do not accept the recommendations and decide that those are harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years? Do you have any felony convictions in the past 10 years? Are you currently on probation? You understand that by successfully completing a diversion period, charges will be dismissed pre-trial, averted, and you get your record expunged. Do you understand that? You understand if you don't complete it successfully, you'd be brought back before the court. I could revoke your pre-trial diversion and schedule a sentencing hearing. At that time, you would be a convicted felon. After I sentence you, and that could be used against you. Future convictions under persistent felony offender law. You understand that? Ms. Gordon Anderson, will you state what the Commonwealth's recommendation is?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances first offense, the defendant shall pay a fine of $200. The defendant shall be assessed and follow any recommendations of the social services clinician. The defendant shall pay fines and court costs at the discretion of the court. Defendant shall gain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agree to? You understand that the DUI is enhanceable too. If you get another DUI, it's more, it'd be more stringent. Is that correct?
So,
Are you pleading guilty because you did commit the acts charged in the amendment as in the indictment as amended?
yes, sir.
Are you doing this over your own free will?
Yes, sir.
One of your constitutional rights to explain to you is 2 years out, give up those rights. Plead guilty to the charges, allow the court to fix your punishment as allowed by law. Set your signature on the motion and offer.
Yes, sir.
Accept the pretrial, the plea and the pretrial diversion. What did the court cost this case?
$875.
Court costs are $875, primarily because of the DUI. You need some time to pay that?
Yeah.
Can you pay $70 a month? $50?
Yeah, yes, sir.
$50 better. I don't want to give you anything you can't do because then you have to be up there. Okay, so you make a first payment 30 days from today. $50 every month until you get that paid off, okay?
Yes, sir.
Now, I also want you to meet with the probation and parole officer back there and give them your information. I hope you're not back up here again. Okay?
Yes, sir.
Sandra Wallace. Sandra Commonwealth versus Sandra Wallace, 24 CR 0021. Are you Sandra Wallace?
Yes, sir.
You born in 1971?
Yes,
Last 4 digits, social security number 5269.
yes.
We're here on a pretrial conference. What does the Commonwealth have to say?
The diversion plea, Your Honor.
Ms. Wallace, I understand that you wish to enter a diversion plea today. Is that correct?
Yes.
Are you currently on the influence of drugs or alcohol?
No, sir.
This plea freely and voluntarily given.
Yes.
Okay, are you the same individual we just identified as far as your social security number and date of birth?
Yes, sir.
This is 24 CR 0021. Is your judgment impaired today?
No.
You discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
You have plenty of time to review the evidence against you. You believe you're fully informed about your case. You're fully informed about your case? Are you fully informed about your case?
Yes, sir.
Okay. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution.
Yes.
Before I can accept a plea, I need to go over those rights, and then at the end, I'll ask you if you understand them. If you got any questions, anytime, you can step away from the podium and ask your attorney, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial. You have the right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by hearing a plea of guilty, you give up all those rights. You understand that?
Yes.
Okay. I may consider the Commonwealth's recommendation, but I may apply any range of sentence without the law. I don't have to accept the recommendation. In the event that I don't accept the Commonwealth's recommendation and decide to put a harsher sentence on you, you have the right to withdraw your plea and go to trial. You understand that?
Yes.
Okay. Now, you understand that if you fully complete the diversion agreement, the charges will be dismissed, pre-trial diverted, and you can have your record expunged, have it taken off your record. You understand that?
Yes, sir.
Hey, I'm gonna ask you some qualification questions. Have you previously been diverted in the last 5 years?
No.
Have you any felony convictions in the last 10 years? Any felony convictions in the last 10 years?
Oh,
No, sir.
13 years.
Oh, no, sir.
13 years. Are you currently on probation?
No, sir.
Okay. You understand if you fully complete the diversion program, the charges will be dismissed, pre-trial diverted, and you can have this expunged from your record. You understand that?
Yes, sir.
And what's the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to be assessed and follow any recommendations of the social services clinician. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until any and all fines and court costs are paid in full or until further request of probation and parole.
If what you agreed to?
Yes, sir.
Your Honor, let me interject. I didn't make it clear that Commonwealth, I believe Ms. Wallace is receiving disability benefits. So that would affect the employment inspection.
I didn't hear what you just said.
I said she's receiving disability benefits. I did not advise the
It's
Commonwealth.
okay, that'd be fine. Yeah. Has anyone included, are you pleading guilty because you did commit the acts charged in the indictment as amended? You did commit the acts as charged in the indictment as
Yes.
amended, okay? You're doing so of your own free will, correct? Okay, you know your constitutional rights, is it still your desire to waive those rights and allow me to sign this order? Is that your signature on the document?
Yes, sir.
I accept the agreement. What's your court cost?
$250.
$215. You need some time to pay that?
Yes, sir.
Okay, you can pay it $30 a month. First payment starts 30 days from today, okay? You need to meet with the probation and parole officer right there.
Thank you.
Savannah Warner. Commonwealth versus Savannah Warner, 24 CI 0024. You are Savannah Warner,
Yes, sir.
born in 1997.
Yes, sir.
Last 4 digits, social security number 9615.
Yes, sir.
You're here with the purpose of arraignment. You have the right to remain silent. The counsel's with you. If you have any questions, step away from the podium and ask it, okay? The grand jury of Cumberland County charged you with assault 3rd degree, which is assault against a police officer, resisting arrest, operating under the influence, possession of open alcohol container, careless driving, and failure to dim headlights. Counselor, you acknowledge the identity of Ms. Warner, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Ms. Warner, as a condition of your bond, you should be in Clinton County at 9 a.m. on June the 7th for negotiations, and be back here on June the 27th for your next court appearance. If you haven't reached an agreement on that date, if everything's ready, we'll set your trial date, okay?
Judge, if I may, very briefly, Ms. Warner had asked me before we come up, she with this weekend being Memorial Day, obviously wants to adhere to the court's conditions. She was asking if she could go for grave services and be permitted. I know typically you allow for work, church,
Somebody in
school.
her family died recently or something.
It's, well, to go to the gravesite for Memorial Day. I don't think it's a recent. Flowers on the gravesite.
Is the gravesite at her church?
Yeah, I don't have any objection.
Is it a church service?
No, they just go to the graveyard to do
It's
a
the.
memorial with
Decoration.
flowers.
So you just need to, how long you usually spend there? I just want some specificity, you know, I mean, I don't want anybody riding around saying, well, we're going to the grave tomorrow or this afternoon or something.
Well, no, I understand, Judge, and I think.
She just needs to give some
Would you be
specific.
going with her?
Yes.
Okay, this is grandmother, Judge, and I think grandmother would be the one transporting, so.
Okay, we'll just put that in a order, the grandmother's
Absolutely.
show. They can pick a 2 hour period that they'll notify the pretrial people of, and they can go decorate the graves, okay?
Yes, Your Honor,
No
thank you.
problem. Okay, thank you. We have some Monroe County cases here. That are Mr. Bell's cases. First one is Commonwealth Kentucky versus Hannah Lyons. For sentencing. Yes, sir. This is 24 CI 002. Are you Hannah Lyons? Are you Hannah Lyons?
Sir.
Were you born in 1997?
Yes.
Last four digits, social security number 6857. We're here today,
Yes.
we're here today for sentencing. Have you had an opportunity to look at pre-sentence investigation report done by probation and parole? You have a copy of that to me.
I have a copy, Judge.
Have you reviewed this, ma'am?
Yes, I have.
Is there any reason this lady should not be sentenced?
No, Your Honor. She got a job in Level Daily Minutes to do that. Please, Court, Your Honor. Only change of that, she does now have an appointment. She's working at the eating table. That'll be the only change within the document.
I'm having a hard time deciphering this. It's not sit out like they usually are. Okay, she pled guilty to trafficking in the first degree, first offense, is that correct? On plead guilty to that charge, she shall receive a sentence of 5 years, probated for 5 years. She'll enter Monroe Circuit Court, drug court. Has she done that? She shall remain.
Sorry.
Yeah, hand that back to me. Defendant shall receive court credit for the jail time served. She shall obtain gainful employment. Of course, that's part of the drug court. She said she is working now.
Yes,
The evidence will be disposed of according to law. And what are the court costs over there? $190. You'll need some time to pay that. I'll let you start paying it. $30 a month, start 30 days from today, okay?
Yes, sir.
And when can you, she'll still need to meet with a probation parole officer at some juncture in Glasgow, is that correct? Or-
Yeah, I don't know what his schedule is like, so if she can call there and make an appointment with, Chase.
You can give her the number,
Judge.
Mr. Bell. Yes,
Judge, she's already actively enrolled in the Monroe County Drug Court.
yeah, but she needs to check in with probation parole anyway. They won't supervise her, they just need to get information, isn't that right?
Correct.
Yeah. So you're actively in that. You can just ask your person there at the drug court, your drug court contact to have them line you up with probation parole when you, so you can talk to them. They might be able to do that over the phone.
Right.
Okay? Okay, thank you. Commonwealth of Kentucky versus Jonathan Russell. Are you Jonathan Russell?
Yes, sir.
Were you born in 1978?
Yes, sir.
Last four digits, social security number is 7142.
Yes, sir.
We're on 23 CR 00012 and 24 CR 0018 for pretrial conferences, and there's motion to consolidate these cases. Is that correct?
Yes, Your Honor.
What do you have?
Your Honor, Mr. Hunley filed a motion to consolidate, and if Mr. Bell is not going to agree, I'd ask that we set it for a hearing at the Monroe Motion Day. Which would
Okay,
be,
tell me something about it.
it's, Mr. Hunley knows a lot more about the case than I do, but my understanding is after the victim was shot, there was some guns removed from the residence and taken somewhere else, and there was an additional tampering charge. And he's filed a motion to consolidate. You correct me if I'm wrong, but I think that's the gist of it.
That's correct, Judge. There is some case law, and I will be filing a motion concerning that charge, but I don't have any objection to it consolidating right now.
Okay, so we'll just tender an order then. I think you're that.
Okay, now when's his next court date?
Well, I guess it'll need to be assigned for trial at some time. I would suggest if Mr. Bell's got motions to file that for the 20th and hear the motions and then get a trial date.
June is 20th is
Yes.
the next.
Monroe Motion Day.
You need to have all your motion filed by June the 10th. We can hear them on June the 20th.
Well, okay, Judge, I'll be out of town for a couple of weeks in June, but I'll try to get that done. I thought the next date was June 27th.
That's Cumberland County. It's 20th in Monroe.
Okay.
Yeah.
This is Monroe County case.
Yes.
Unless you want to move it over here.
I wouldn't matter to me. June 20th.
Yeah, you know, to get to Monroe County, right there at that crossroads, you take a right. Right there.
Yes.
You're unfamiliar with the way over there.
Yeah.
Maybe Mr. Russell can help him find a way. over.
Yeah, I call him, he can give me some guide. Maybe I can follow him in, Judge.
Okay, I'll let you remain free on your bond and you stay under the same conditions and you'll be over there on the 20th. Okay, thank you. Chad Shirley.
Consolidation case. John, are you available to be set?
Commonwealth versus Chad Shirley, 24 CR 029. Good morning, Mr. Shirley.
Morning.
Were you born in 1990, sir?
Yes, sir.
Last four digits, social security number 4625.
Yes, sir.
Okay, you're here on a pretrial conference with your attorney, Mr. Bill. What's the Commonwealth have to say?
Your Honor, if we can have the June 7th negotiation and June 20th, I think I'll have some additional discovery to furnish Mr. Bell.
Now, the June 7th will be,
That'll be in Monroe County. I'm having all three negotiation days on the same day. But Ms. Anderson, Gordon Anderson, Mr. Hunley will be doing the one in Monroe and I'll be doing the Cumberland and Clinton County.
okay, June the 7th, 9 a.m. over there in Tompkinsville. And then June 20th will be the next court date, correct?
Yeah.
You remain free on the same bond. Benjamin Tooley. Commonwealth of Kentucky versus Benjamin Tooley. 24 CR 0020. Are you Benjamin Tooley?
Yes, sir.
Good morning. Were you born in 1987?
Sir.
Last four digits, social security number 2174. What's the Commonwealth have to say?
Your Honor, I've been waiting on the case that Mr. Tooley has in Allen County. It was set for trial, but it wasn't tried. I don't know why it wasn't tried.
They dismissed some charges against some co-defendants and they ain't witnesses.
So there's no trial date yet. I was kind of waiting on what to do with these cases, determine what to do with
When's
Mr.
his next court date over there?
Judge, they didn't give us another court date till July the second because of the election and Mr. Morgan was running in and they wouldn't give us a trial date till they knew whether or not he was still going to be the Commonwealth attorney or not.
Did he win?
I don't have no clue.
Well, Mr. Tooley since picked up a possession charge and had a drug test, so I'm going to ask that he be assessed with SSC and follow any recommendations of Mr. Collins in the meantime. Okay.
We've
it's been
done
done.
that.
Okay.
We've done all
I
that.
know I missed a month because I was sick, so I
Yeah,
messed up.
Yeah, we've done all that.
So when do you want him back in court?
I would ask for the July motion day in Monroe. It would be the 18th of July.
And when are you gonna be back in court over in Allen County? You said the 21st of July, did you?
Second, I thought.
Bill,
I was looking at Judge, I think it is the second, yes, sir, July the second.
so you'll know something about
Yeah,
Allen County by then.
Yeah. And what was the date, July?
July the 18th, motion day in Monroe.
Well, what is the negotiation day over there?
It'd be July the 5th.
Well, let's set the negotiation day for July the 5th and then let him be over there. And that way, if he's over there on the 2nd, you'll have some idea on what to negotiate about, maybe wrap it up. What is the charge over in Allen County?
Manslaughter.
Okay, well, they might consolidate the charge.
Sir, Judge.
Okay, continue on the same bond. Now, let me tell you something though. If you have any more violations, and anything like that, we're gonna revoke you. Probably should already have, actually, but. Okay, thank you. Now that concludes is there anybody else here on the live docket here in Cumberland County?
Yes.
Scott's been processed.
Y'all see if Mr. Scott's ready? Bring Mr. Scott.
Have you got Jose?
I don't have any Jose anybody. Who is he?
Jose,
Check with Mr. Bell.
Has he been processed?
We've got him on the Monroe County case. Are these live cases down here?
Not Scott.
They're scheduled at 10. It's Jose, where. Somebody needs to turn their microphone off. Okay, Crittenden County will be right with you if you could flip that microphone off till we get there, okay? Got one more case. Commonwealth versus Kelly Scott. Mr. Bell, I told you at the 10 o'clock docket, we have your Jose Cubano for arraignment.
yeah, he's gotta be processed, Judge.
Okay.
Thank you.
Are you Kelly Scott?
Yes, sir.
Okay, were you born in 1996?
1966.
1966 rather. Last four digits, social security number 4982.
Yes, Your Honor.
You're here on 24 CR 0028 for arraignment. The grand jury of Cumberland County has returned an indictment on you, charging you with possession of controlled substance methamphetamine, in the first degree, possession of drug paraphernalia, possession of marijuana, and failure to use a seatbelt. You understand those charges?
Yeah.
You acknowledge the identity of your client, proceed indictment, waive formal reading and arraignment, enter plea of not guilty,
Yes, Your Honor.
sign a reciprocal discovery order. You want this gentleman here on June the 7th?
Yes, sir.
And then the next court day is June the 27th.
Your Honor, I note that I'll be out on the 27th. I'll either have this field here or I'll give it to Dr.
Now, what's the amount of his bond? Okay, he hadn't made a bond yet.
He made a bond in district court.
Well, he hadn't made a bond
No,
here,
He's not.
so he's in the custody of the jailer till I review the bond.
Well, as word of explanation, we represented Mr. Scott in district court. I'm not.
As a word of explanation, he's in custody till I review the bond. Okay, I'll review the bond today.
Okay.
And you have somebody that can make, what was the bond in district court?
He was staying already.
What?
He was released and transferred.
Yeah, so he didn't make a bond there either, so. So he's in custody and I'll review the bond. And you have somebody can come sign a bond for you, Dave?
I didn't know. You have your wife's here, correct? But she's arrested in Clay County, Tennessee, but she's present.
She can't sign a bond.
Right. Do you have anybody in Cumberland County to sign without putting anybody?
Anybody in Kentucky?
I'll
Period.
go.
Okay, that'd be fine.
Judge, if I may, you had asked to contact Mr. Owsley. He here, we've been here about 10-15 minutes.
That'll be good.
And Judge, what we did was just to clarify, I don't know if the order will need to reflect this. Mr. Stockton and I agreed to have Mr. Owsley come in on July 5th for that negotiation day. If we've got the labs, we'll do paperwork that day. And I'm giving Mr. Owsley both dates.
Is he coming in now? Is it him? I can't see that.
No, he's here.
Okay, Mr. Owsley? Yeah, I'm not gonna issue a warrant for you or anything because you come in now. I'm gonna give you an opportunity to come down. And your attorney will give you the dates and what you gotta do and you'll comply. Is that correct? Okay, thank you. You may be on your way rejoicing.
Thank you, Judge.
Yeah. Okay, let's go to Crittenden County. Crittenden County.
We got, one more out of custody, Your Honor, Mr. McClendon's back here.
I didn't see him on the dock.
Well, he's actually got Byron County Jail, but he's on the docket, live docket, should have been on the live docket.
He's still number one, but it's.
Okay, we'll get to him in just a minute here. Crittenden County, are you on the line now? Crittenden County?
Yes, Your Honor, can you hear us?
Well, we can now, thank you. This is Commonwealth of Kentucky versus Shannon Walters, 21 CR 0062 and 21 CR 00146. Are you Shannon Walters?
Yes, Your Honor, I am.
Are you born in 1978?
Yes, Your Honor.
Last four digits, social security number 8119.
Yes, Your Honor.
We have motion for shock probation. Your attorney's present here. Would you proceed?
Well, Judge, I think this is a review of the motion. This was actually on last month, and this is to review. I've discussed this case with the Commonwealth. They are not in agreement at this time.
What's the underlying charge, Mr.?
He's got a theft by unlawful taking over $10,000. He got 7 years and 6 months on that. And, then he's got a possession, which he had 3 years, but they were run concurrently for a total of 7.5 years. And this involves a stolen 2016 Sierra GMC from Mike Humphrey. The major problem I had with him, he was out of pocket for about 13 months while he was on probation. We filed our motion to revoke, I think, December of 22, and then
He absconded?
yes, and that's the reason I'm opposed.
Do you have any argument to make on that?
You know, Judge, I would say that in my motion, I asked for Mr. Walters to be able to get some substance abuse treatment. I actually proffered for him to go to rehab.
Was there any restitution owed on the?
I think Mr. Humphrey wasn't concerned about it. It's like $1,900. I don't know if any of it was ever paid or not. The clerk could.
Wasn't in order. Wasn't in any order.
Okay.
Yeah.
I'm asking, that is a question. It wasn't in any.
No,
Okay, well then I can't order him to pay any restitution on
Yeah.
it. Well, considering that that he absconded for that period of time, I'm not able to, in my opinion, to do a motion for shock probation because he did not comply. Okay, well, thank you very much, Crittenden County. You may be excused.
Thank you.
He does it, Mr. said he did owe restitution.
Okay, I couldn't recall. I didn't check on that.
And he's right on the amount, about $1,900.
Did he ever pay you? I didn't pay
22, he made 3.
before he left.
And Judge, I would just ask, you know, again, if Mr. Watts were able to make that restitution right and make the victim whole, if the court
You
would
need to talk to
consider.
Commonwealth about that.
Yes, Your Honor.
They might have an opinion on that. I don't
Okay,
know.
thank you, Judge.
Davis County, are you on the line? Davis County? Casey County, are you on the line? Casey County?
Yes, but the host has got us blocked. Here we go. Got Robert
You're
Young.
unblocked. Okay, thank you very much. Commonwealth of Kentucky versus Robert Young, 22 CR 0025 and 24 CR 0020. Are you Robert Young?
Yeah, I'm Robert Douglas Young.
Yeah, were you born in 1978?
No.
Last four
1984.
digits. Pardon?
1984.
Yeah, Judge, that's not.
Well, is this guy the wrong guy? What, Mr. Stockton?
Yes.
We might have a misidentification here. This is Robert Young. It's in Casey County. Doesn't appear to be the same Robert Young.
So he's not born July 21st, 1978.
Now, what year are you born, Mr. Young?
1984.
Yeah.
Social security number doesn't end 3613.
Your social security does not have 3613.
No.
Okay, well, congratulations. You don't have anything in Cumberland Circuit Court. So, we'll contact the other Robert Young. Casey County, y'all may be excused, okay?
Judge,
Go ahead.
I believe the Robert Young we're looking for, last I checked, Monday, he was in the Adair County
Okay.
Detention Center.
Casey County, y'all may be released.
Okay, thank you.
Davis, thank you. Davis County, are you on the line?
Yes, Davis County's here.
Davis County, will you turn your camera on? There you go. Brandon Horn.
We're waiting on the inmate to be brought over. We just received the email.
Okay. You want to go off and I'll call you in just a few minutes when he gets there?
Yes, sir.
Okay. Lee Adjustment Center. Are you on Lee Adjustment Center? Lee Adjustment Center.
Yes, Your Honor. It says the host says stop the video. Okay, here we go.
We'll start it back up again.
There we go.
There you are. Commonwealth Kentucky versus Michael Carroll, 24 CR 00012. Are you Michael Carroll?
Yes, Your Honor.
Born in 1984.
Yes, Your Honor.
That's 4 digits, social security number 1173.
Yes, Your Honor.
Okay, we're here on a pretrial conference. What does the Commonwealth have to say?
I would ask for the same court dates that Miss Lindsay was given. I think she was given the June negotiation day, and I think because her attorney had a conflict, it's July motion day.
Okay, there'll be a negotiation day on June 7th and in July what?
25th.
July 25th. And I would like transport orders done for Mr. Carroll to transport him for the negotiation day so you can be present with the co-defendant and your attorney. I find it very difficult to negotiate without you being there.
And Judge, he would have been here for a while. I think he's been moved a little bit. Michael, are you in your final destination right now, or are you gonna be moved again?
How would he know? He doesn't know what he's in his final destination. Mr. Carroll, we'll do a transportation order and have you here so you can negotiate in person with your attorney on June the 7th, okay?
Thank you, Your Honor.
Thank you. Lee Adjustment, you may be excused. Thank you for your cooperation.
We're done.
Putnamville Correctional Facility. Putnamville, are you on there? Putnamville Correctional Facility. Okay. Taylor County Detention Center,
Yes, Your
Taylor County Detention Center, okay, we'll unblock that. Thank you. Commonwealth of Kentucky versus Jason Bowers, 22 CR 00082. Are you Jason Bowers?
Yes, Your Honor.
Okay, were you born in 1984?
Yes, sir.
Last four digits of your social security number are 7956.
Yes, sir.
We're here on a motion for shock probation. What do you have?
Judge, I've discussed this case with the Commonwealth, and I believe we're in agreement on a resolution to have Mr. Bauer transported to a rehabilitation center.
What do you have to say, Mr. Stockton?
I
Yeah,
want to fully inform the court, you were reluctant last time, Your Honor, because this is the one that involved the shooting where he's discharging a gun. And I recommended a dual diagnosis facility. And I think you have found one.
Correct.
And one reason I'm willing to do this is Mr. Bowers is ex-military. He served our country. When he got the DUI, he was very cooperative, went ahead and entered the plea and was a rope. Now, I'm kind of like the end of the Gladiator movie. He's been a soldier of Rome, so treat him as such.
well, here's,
But I understand the court's reluctance because of his problems.
is he gonna go for this dual diagnosis before we do the shock, or you recommend I do the shock and then?
He'll have to be shocked out into it because unless there's a facility in corrections that can take him.
And Judge, I've discussed this. I've reached out with probation and parole, SSCs in multiple counties. When Mr. Bauer's diversion was revoked, that made him ineligible for, I guess, a program the Department of Corrections has to where it could be a kind of quasi behind the fence rehabilitation. As such, there's not a center with his status now that he could go to.
Where is there one if his status changes?
Are you the
Well, I mean, I'm willing to work on this if you'll tell me where he's going, but I'm not gonna shock probate him to someplace that does not exist.
What was the name of the place? You have it, James?
Judge, I have a bedwetter with ARC Rehabilitation.
Do they have a facility that will do the dual diagnosis?
Yes, Your Honor.
Okay, where is it located?
Judge, they have centers all over the Kentucky, the
Well,
particular.
the centers all over Kentucky all of them don't have that, I'm sure.
Judge, actually, yes, all their.
Well, you need to inform Mr. Stockton about it, about the dual diagnosis, and I appreciate this gentleman's service to the country. But there are people that are veterans that are criminals,
I understand, Judge.
and there are people that are veterans that are dangerous. And I'll give him the benefits of the doubt, even more because of his service. I appreciate his service. So you convince Mr. Stockton and get ARC to tell you what facility they'll refer him to and what kind of treatment they have, and I'll sign an agreed order, okay?
Yes, Judge, thank
Okay,
you.
they'll be in contact with you, Mr. Bowers, okay?
Thank you, Your Honor.
Okay. Taylor County, you may be excused. Now, what was the other facility they were gonna go get somebody from here?
Davis County.
Davis County? There you go. Davis County, you got the prisoner in front of you now? Okay, there you go. Davis County, Commonwealth, Kentucky versus Brandon Horn, 19 CR 0009. Are you Brandon Horn?
Yes, sir.
Were you born in 1983?
Yes, sir.
Last four digits, social security number 3834.
Yes, sir.
Okay, we're here today on a stock probation revocation motion. What does the Commonwealth have to say?
I think that Miss Lindsay should be Jennifer Lindsay's the witness in this case.
Jennifer Lindsay, will you turn your camera on? I guess we've got Miss Lindsay. There's Miss Lindsay's camera. Okay, would you call your first witness?
Yeah, Jennifer Lindsay,
Will
please.
you raise your right hand, Miss Lindsay? Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, thank you very much. You may inquire.
Miss Lindsay, have you been supervising or attempting to supervise Brandon G. Horn?
I have.
And I really want to start on what's happened since February the 16th of 2024. Has he had any violations?
He has.
Can you tell the court what's happened?
Oh, I apologize. I didn't have, I thought it was just motion hour today. Since February 16th, he reported to me on March 21st, and stated that he would, complete a graduated sanction to go to outpatient treatment. And then was given a report day of April 18th. You wanted me to go back to February. I'm sorry.
Evidently, he reported to you on February the 16th, and you was going to do a drug test, and he did an admission instead. Is that correct?
Yes.
Okay. And what did he admit to the use of?
He admitted to using methamphetamine on or about the 15th and signed an admission sanction form.
Okay, and then what did you have done after he admitted to the use of methamphetamine?
Okay. He was scheduled for an appointment with the social service clinician on March 5th. And then when he showed up for the social service clinician appointment, he was drug screened and was positive for methamphetamine.
Was the 5th.
And he admitted to using on or about March the 2nd.
Okay. And what did the SC recommend then?
They recommended for him to enroll in and complete SAP IOP at River Valley Behavioral Health.
Okay. And did he do that?
No, he didn't. He reported to me on April 26th. Let's see, he admitted to using methamphetamine in lieu of being drug screened, and he signed an admission sanction form. And then his first class for SAP IOP was supposed to be on March 21st. And then as of April 26th, he never did attend any of his SAP IOP classes.
Did he fail to report to you in April?
Yes.
And was that April the 8th?
Yes, he failed to report to me on April 18th. That was the follow-up report day he was given when I saw him in March. He contacted me on the 19th.
Okay.
And I rescheduled him to April 22nd. He failed to report again. He texted me and asked me to reschedule. So I rescheduled him to April 25th. He didn't report again. And then I finally got him to report on April 26th.
Okay, and what did you recommend? What happened then on April the 26th?
Prior to him showing up, I had emailed just to confirm that he did not attend any of his SAP IOP appointments. I was informed that he didn't. So I called the social service clinician while Mr. Horn was in my office. Her recommendation was that he do a 30-day inpatient program. Mr. Horn completed the interview while he was sitting in my office. We arranged transportation for him, and he was supposed to enter the program.
Okay, what program was that? Was that Genesis in Hopkinsville?
Yes, it was.
And
when he left my office, we had it all worked out. The day he would leave, who would be picking him up. I sent him a list of items he could take. I gave him a follow-up report day with me for the following month, or 30 days out, just to give him time to, complete the program. So, I mean, he was good to go. And then
Go?
he did not.
Okay. And subsequent to him not going to Genesis on April the 1st, did he pick up any new felony arrests?
He did.
And where was that and what was he charged with?
He was charged, or he was arrested and charged on May 12th by the Davis County Sheriff's Department with enhanced possession of a controlled substance, methamphetamine, and enhanced possession of drug paraphernalia.
You also have in your report, he was associating with a convicted felon, is that correct?
That is.
And was that on May the 12th also?
It was. That was the passenger in his vehicle.
Okay, I have no further questions, Your
Would you
Honor.
like to inquire, counsel?
No question, Judge.
Okay,
I'd ask based on Mr. Horn's total noncompliance since February of this year, despite all this officer's efforts to try to get him help, he just utterly failed to take advantage of it.
Judge, I'll just ask, the testimony's been clear from the officer, Mr. Horn has a substance abuse problem. In fact, the last request was for him to have inpatient treatment. Argue should have been one of the first requests. Judge, I'm asking that now for his behalf to be able to.
he's had these opportunities and unfortunately hadn't complied, so I'm gonna revoke his shock probation. And he can, and then hopefully they'll take his Davis County situations and maybe they can roll it up on him and get him some help down there.
Yes,
Okay,
Your Honor.
thank you, Davis County, for your cooperation and your patience.
Hey, sir.
Yeah, you may
I
be,
wasn't driving
maybe
that car
you-
that
okay,
night.
thank you.
Also, they done dropped my charges.
If y'all will take care of that, you
Sure.
don't say anything that might incriminate you. You need to talk to your lawyer about that. Okay,
Okay, well, they dropped my charges.
thank you. Okay, Putnamville Correctional Institute. Did you ever come online? If not, let's go to Barron County. Barron County, are you still on the line?
Barron County's never been on.
Barron County's never been on the line. Mr. Bell, you want to call your friends at Barron County and see if you get them online?
Let
me call them, sir.
Yeah.
We got one in Clinton County, one in Cumberland. We moved these here for you today.
They used to say, well, I resemble that remark.
That Young's in a dark county. Dark county.
Probation and parole, their brother correctional institution. Can you call over there, see if you could?
Don't like me either, just.
Yeah. Okay, let's go to Adair County then. I guess you have Mr. McClendon here live. Let's do Mr. McClendon first, okay? Okay, well, we'll get to, remind me to get to Mr. McClendon next. We come back.
Here comes Mr. Bell.
Mr. Bell, you have Mr. McClendon here in person.
Yes.
You told me.
Yes.
You want to call his case around? Commonwealth versus Robert McClendon, Monroe Circuit case number 23CR 0072. Good morning, Mr. McClendon. You were born in 1972.
Yes.
The last 4 digits, social security number 9729. You're here on a pretrial conference. What do we have?
Have a misdemeanor plea, Your Honor.
Okay. Mr. McClendon, a motion's been tendered, says you wish to enter a misdemeanor plea today. Is that correct?
Yes, Your
Are you under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in the indictment?
Yes.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Are you view the evidence the Commonwealth has against you, you believe you're fully informed about your case?
Yeah.
Do you understand that you don't have to enter a guilty plea today? You have certain rights under the Kentucky United States Constitution. I'm gonna go over those rights and ask you if you understand them at the end. You have a right not to testify against yourself. No one can make you say anything. Your right to have a speedy trial by jury, the right to be represented by counsel at your jury trial. the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt the guilty charge against you. Understand that by entering guilty plea, you give up all those rights.
Yes, Your Honor.
Understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. This is a misdemeanor, so I don't have to have a pre-sentence investigation report. But in the event that I do not accept the Commonwealth's recommendation and decide to impose you to a harsher sentence, you'll have a right to withdraw your plea.
Yes, Your
And
Honor.
proceed to trial. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
On a plea to assault fourth degree, the defendant shall receive a sentence of 7 months, probated for 2 years, unsupervised. The defendant shall have no contact with the victim. The defendant shall pay $1,000 fine. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
The only exception we would take is the fine would be probated.
It doesn't say that, but we'll check.
That's correct. That's what under the
Yeah.
That's all, that's.
Okay, well, that's a pretty big difference, split probated out. Okay, are you pleading guilty because you did commit the acts and the indictment is amended?
Yes, Your Honor.
Okay. Knowing your constitutional rights, is it still your desire to give up those rights and allow the court to fix the punishment within the range permitted by law? Is that your signature on the doc?
Yes, Your Honor.
Okay, well, I accept the agreement. And you'll need, even though it's unsupervised, you will need to check in with a probation parole officer there to give him the information. What are the court costs, you know, on that? What was on the other one? 190, court costs.
I pay next week.
Well, you don't have to pay it that soon. I was gonna let you pay it like,
Pay it next week.
okay, well,
I'll give you 30 days.
I'll give you 30 days to pay in case something comes up. Okay.
Thank you.
Okay, well, thank you very much. The probation parole officer talked to you right over there. Okay, now, you have anybody else alive here?
I got the, Jose Quijano. Right in the back.
Yeah, we'll bring him out.
I believe he's on judge for an arraignment. Pretty good, good enough, I think.
Translate, I know that's what I'm supposed to.
Well, we want to make sure that he understands what's going on. I never will forget when I was still practicing, we had a translation done. And there was a dispatcher that was helping translate when they took the guy into custody. And we had it translated, written up for me, and the whole time during the translation, she explained it's right. She's trying to talk him into plead guilty. Which was frowned upon, would have been frowned upon by me at the time.
Yeah.
Hey, Jose, how do you pronounce your name?
Jose.
How do you pronounce your last name?
How do you pronounce it?
Hernandez.
Okay. Were you born in 1984?
Yes.
Yeah. And you're here for arraignment in 24 CR 0031. Do we have the file here? You have a copy of that?
We don't have extra, we must have our.
These extra copies, no, this is a reciprocal. Y'all ran out of white paper.
That's the way we are.
Technology.
That's pretty slick. I'm gonna start doing that myself.
You got it. Pretty slick.
Back and, color told you, diapers in your lounge. Old constable, he come up with one every once in a while.
You're never too old to learn,
No, I ain't too proud, either.
nor should you be.
Well, still an idea, the minute, it's a good one.
What did Barron County say?
Before doing the Zoom email, and I guess they weren't too happy with us calling.
Sorry, Bob.
They didn't like me calling, but I told them I hope you don't mind. I told
Okay,
them
the grand jury has returned an indictment charging, the defendant, also known as Jose Hernandez, with operating a motor vehicle under the influence, bribery of a public officer, terroristic threatening, operating with expired license or no license, failure to maintain insurance, disorderly conduct, and criminal mischief in the third degree. You acknowledge the identity of your client.
Yes.
Proceed the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, what did I set the bond for this gentleman at in it originally? Does anybody know?
There's no one current that judge, he posted it, they started $10,000 cash bond, but the warrant didn't have any bond listed.
Is the money still there?
To my knowledge, I looked at court and it still shows posted up.
It's still there, Judge.
Okay.
The clerk called from everybody downstairs, it doesn't still need it.
Okay, well, I'll allow the $10,000 to continue as his bond.
Thank you, Judge.
Yeah.
Be free to go.
Well, we have to give you some dates.
Oh,
It'd
yeah.
be good to give you some dates, you know. When do you want,
June the 7th at 9 in Monroe County.
June the 7th at 9 a.m. in Monroe County, and the next court date would go over there be June 20th?
Correct.
Both of those are condition of his bond, so you should have him come meet with you before June the 7th to discuss the thing, and then you go through negotiations on June the 7th, okay?
We'll need to go to the road.
That was cash.
They just need to do a circuit bond.
You won't have to sign it. Yes,
There is a bond decision. There is a bond set in this case. It was already 10.
what is it? How much?
10,000 cash, 10,000 cash for 2 times property, pretrial monitoring, 24-hour curfew, random drug and alcohol.
Okay, he already has 10,000 cash posted over there, so the bond decision will stand. And we had those curfew things as far as him being work, church, the doctor conditions. So he'll probably need to just stop over there and sign it then, because those additional conditions that we put on it. Can y'all put that on there as far as the curfew? You need to explain that to him. Okay? You need to go to work, church, doctor. I'll let him stay and give an address. He just needs to go over there and just sign those additional conditions. Can he sign them here? Y'all can take that bond here. Tracy, y'all can take that bond here with those additional conditions in your Oak County bond.
Yes, is the surety here to sign it? The one that's
It's
supposed to be-
cash.
I know, but.
Whose cash was it that was posted?
His landlord, Judge.
The landlord will have to sign that. Additional.
Well, we won't make any additional bond then. I'll just leave it $10,000 and transfer it over. Okay,
Thank you, Judge.
okay.
He's free to go.
Yeah, he's free to go.
When will they know for him to sign what he needs to, Judge?
I'm not gonna make him sign
Oh,
anything.
okay.
I'm just letting that bond be transferred over to be his circuit court bond. Okay. Okay, let's go to Adair County. If anybody notices when Barron County comes on, just tell me. Adair County. Mark Cruz. For Dare County. Commonwealth versus Mark Cruz, 24 CR 0014. Are you Mark Cruz?
Yes.
Were you born in 1960?
Yes.
Last four digits, social security number 3369. Your attorney is present. What does the Commonwealth have to say about Mr. Cruz?
Felony plea, Your Honor.
Mr. Cruz, a motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in indictment number 24 CR 00014?
Yes.
Your judgment impaired, sir, today in any way? Is your judgment impaired in any way?
No.
And you discuss these charges with your attorney, and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Do you feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I'm going to go over those rights, and if you don't understand some of them, I'll give you an opportunity to meet with your attorney. I'll ask you at the end if you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor, a right to appeal this matter to a higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Understand that.
Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event I don't accept the Commonwealth's recommendation, decide to impose a harsher sentence, you'll have your right to withdraw your plea. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant
Okay,
shall.
well, we got a problem. That's not key in the mic for some reason. Will you move over here to this other?
Yeah.
See, use the mic. Go ahead, try it again.
Upon a plea of guilty, is it going down? Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. Upon a plea of guilty to possession of a controlled substance, second degree, the defendant shall receive a sentence of 12 months. These two sentences are to run concurrently. The defendant shall receive credit for time served. The defendant shall be released at final sentencing. The defendant shall be assessed and follow any recommendations of the social services clinician. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts in the indictment as amended?
I'm pleading guilty.
Okay. Knowing your constitutional rights, as I explained to you, is it still your desire to give up those rights and allow the court to fix your punishment within the range permitted by law?
Yes.
You understand that after entering a plea of guilty, if you have future felony convictions in Kentucky, this could be used to enhance your range of penalties. You understand that?
Yes.
Okay, could you have the document here? Sorry, is that your signature on there?
Best I can tell. Yeah.
Okay, can you see? Okay. Yeah, I would accept the plea order pre-sentence investigation report. Sentencing shall be on on June the 27th. Was the agreement he would be released on the 27th?
Final sentencing, Judge.
At final sentencing, so they'll be up to meet you, do a pre-sentence investigation report, and on the 27th, you need to have somebody ready to pick you up, okay?
Yes, sir.
Well, thank you very much. Charles Dyer. Commonwealth versus Charles Dyer, 24 CR 0018. Are you Charles Dyer?
Sir.
Born in 1973.
Yes, sir.
Last four digits of social security number 5164. You're here today for a pretrial conference. What does the Commonwealth have to say?
Your Honor, I have two things. Number
Can you
one.
speak up a little, just a little
Okay.
bit?
Two things. Number one, and we need another negotiation day. I think Mr. Cross might decide that. Number two, I was informed this morning by text that Mr. Dyer is still contacting the victim from jail on this case. I've not had time to check with her. And if, I don't know, I would recommend him stopping because he may be committing another felony with him contacting her. I don't know. I don't know what he's told her or said to her, but she's requesting he stop.
Okay, and she's requesting it.
She's requesting that he have no contact with her and not be contacted.
And that's
from
his
the jail.
daughter, Your Honor. Charles, do you understand that?
Yes, sir.
He don't like it, but he ought to understand.
You understand?
Yes, sir.
Cannot contact. Okay.
Okay, the next negotiation day would be on June the 7th. And the next appearance here will be on the 27th. So if you want him here in person on the 7th, you'll need to submit.
Well, I won't be here that day, Your Honor. Mr. Stockton and I will meet prior.
Yeah.
Or I may, if I have Ms. Fields here, we'll see.
Okay, thank you very much. Chad Faulkner is next. Chad Faulkner. Commonwealth versus Chad Faulkner, 24 CR 0022 and 24 CR 0011. You are Chad Faulkner. You were born
Yes,
in
sir.
1903, and the last four digits social security number is 7024. Is that correct? Is that correct, Mr. Faulkner?
Yes, sir.
Okay. What does the Commonwealth have to say about that? Okay, a motion, I've been informed that a motion has been filed that says you wish to enter a guilty plea today. Is that right, Mr. Faulkner?
Sir.
Currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
Okay. Are you the same person we just identified in 24 CR 0022 and 24 CR 0011?
Yes, sir.
Is your judgment impaired today in any way?
No, sir. No, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can
Yes, sir.
accept a plea, before I can accept a plea of guilty, I know that you need to know that you understand those rights. Okay, now I'm gonna go down through the rights, and at the end, I'm gonna ask you if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty today, you give up all those rights. Do you understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I'll await the pre-sentence investigation report to be done by probation parole. In the event that I don't accept the recommendation and decide to give them a harsher sentence, give you a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Okay. Listen very closely. Ms. Gordon Anderson, What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance first degree in case number 24 CR 11, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to possession of controlled substance first degree in case number 24 CR 22, the defendant shall receive a sentence of 3 years. These two sentences are to run consecutively for a total of 6 years, serve 100 days, probated for 5 years. Probation is to be supervised. Upon a plea of guilty of operating a motor vehicle with alcohol concentration above 0.08 or while under the influence of alcohol or other substances, second offense, the defendant shall serve 7 days and a fine of $350. The defendant agrees to enroll and complete a long-term treatment center for a minimum of 6 months at Spark in Russell County. The defendant shall not be released prior to final sentencing. The defendant shall pay all fines and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Now, Mr. Faulkner, you were informed when you entered the plea that the DUI was enhanceable. If you got another DUI, it would be more serious. You were informed of that, correct?
Sir.
Okay, and that your felony plea would be, if you got sentenced on it under persistent felony offender law, it would be more serious also. Is that correct?
Yes, sir.
Another felony.
Yes, sir.
Well, I will have a pre-sentence investigation report done. And knowing your constitutional rights, is it still your desire to allow the court to fix your punishment within the range permitted by law? Okay, could you have the document here? Okay. Mr. Faulkner, I'm gonna hold this document up here. Is that your signature on there, Mr. Faulkner?
Yes, sir.
Well, I order a pre-sentence investigation report and sentencing will happen on June 27th. And what are the court costs and fines?
In the 24/11 case, it is $1,000 and the CR 22 case is $185.
That's what?
$185.
$1,185. Okay, the total court costs are $1,185. And I'll go ahead and order you to pay that, but it's 30 days upon your release from incarceration and or treatment that's ordered, okay?
Thank you, Judge.
Start paying $50 a month, whichever the latter of those two happens, okay?
Okay.
Thank you.
Thank you.
Joanna Kittrell. For arraignment, Joanna Kittrell. Commonwealth of Kentucky versus Joanna Kittrell, 24 CI 0027. Are you Miss Kittrell?
Yes, sir.
Okay, were you born in 1997?
Yes, sir.
Last 4 digits, social security number 0105.
That's right.
Okay, you're here for the purpose of arraignment. You have a right to remain silent. Your attorney, Mr. Bennington, is here present in the courtroom. The grand jury of Cumberland County has charged you with fleeing or evading police in the first degree, wanton endangerment in the first degree, another count of wanton endangerment in the first degree, failure to maintain insurance on a motor vehicle, reckless driving, no registration plates, speeding, fair use of. You understand what those charges are? Ms. Kittrell, you understand? Okay,
I
don't want you to say-
understand.
Okay, don't say whether
You
you did it
never-
or not.
Okay.
The way-
Josie,
what
yeah, don't say anything, Josie.
You might incriminate yourself, say something, okay? So, counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions?
Yes, Your Honor. And Judge, if I may, I guess the first of my motions, and I've already discussed this with the Commonwealth, will be a evaluation for Mr. Trail.
By video.
Yeah.
Okay. You get that? Jim?
I wrote that. I was thinking,
Yeah,
you
I
was thinking you want negotiation before or after.
Can't do it till after.
I'm just not gonna do one then.
Okay. What do you want to do? You ask for an evaluation for her?
Yeah, that'll have to be completed before we can have a negotiation days. We'll do the video, so maybe they can do it quite a bit with.
And those been turned around about 4 months as
What,
opposed to.
what, based upon what are you asking an evaluation? She ever been diagnosed with any kind of problem or anything?
Yes, Judge, and I've already been provided medical records from the family and district court. There's a
I
diagnosis.
don't want you to go
Yes.
in, I don't want you to go
Yes.
into it.
It's justified.
Okay, it's just, so we'll order an evaluation for Ms. Kittrell. And then we'll try to expedite that so it can happen as soon as possible. And then if we still have time with the evaluation, then we can set it for the next rule day. If not, we'll set it by agreement. Your attorney will be up, talk to you, Ms. Kittrell. They're gonna do a psychological evaluation to see if that have any impact on your stuff, and they'll try to do it by video so it can get it done sooner rather than later, okay?
All right,
Thank you very much. Michael Neal is next.
thank you.
Michael Neal. Commonwealth versus Michael Neal. Are you Michael Neal?
Yes, sir.
You born in 1971?
Yes, sir.
Last 4 digits, social security number 9811.
Yes, sir.
We're here today in 24 CR 0026 for your arraignment.
This was a grace, yes.
Okay. And y'all done an evaluation to see if he's eligible for a public advocate. Well, I'm gonna appoint Office of Public Advocacy for the purpose of arraignment. And then we'll have, a form needs to be filled out on it. I'll sign it a permanent.
Yes, Your Honor.
Come sign. Mr. Pennington is gonna stand in to you now till we determine whether you're eligible to get a public defender appointed. So you have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with assault in the 2nd degree and wanton endangerment in the 1st degree. And possession of open alcoholic beverage. Now, it says he operated a motor vehicle under the influence of alcohol. Has he already pled in district court or something?
He may have, he tested way over the limit, so.
But he's not been charged with anything.
I'll check. I thought he had been charged.
Mr.
I've been
Pennington,
told he's already pled out in district court.
when you acknowledge the receipt of the indictment, identity of self-identified client, waive formal reading and arraignment, enter plea not guilty on his behalf.
Yes, Your Honor.
Now, appointment, I'm gonna go ahead and sign a tentative appointment with him until we get the affidavit signed. You got an affidavit on me? Okay.
And Judge, if I may, even in my limited capacity, it looks like I'm showing a $10,000 cash bond for Mr. Neal. Is that correct?
Yes.
Judge, I understand we've got a Class C felony here, but I would certainly ask,
Well, you need to at least talk to him before
when
him.
that's for sure, to even.
No,
Okay.
you talk to him first and then get back to the comment and say what it is.
Yes, Your Honor.
Okay. Mr. Neal, he'll be up to talk to you, okay? The attorney will be. Yeah, let me ask you while you're there, raise your right hand, Mr. Neal. Yeah, you swear to tell the truth, the whole truth, nothing but the truth. Do you? Okay, do you have a job or do you own any property or anything, Mr. Neal?
No, sir.
Okay, where do you live?
Burnsville. On,
What do you-
Smith Grove, 1880 in Burnsville.
The Smith Grove here in Cumberland County, not the one over in Warren County, right?
Yes.
You're in Cumberland County. You don't have a job?
No, I'm disabled.
Okay, you're disabled. Well, I'm going to go ahead and make the appointment. Go ahead and make the appointment so he can come up and talk to you about what your situation is, okay?
Yes, Your Honor.
Okay, thank you very much, Mr. Neal. Thomas O'Donnell. Commonwealth of Kentucky versus Thomas O'Donnell, 22 CR 00103. You are Thomas O'Donnell,
I am.
were born in 1961.
Yes.
And the last four digits, your social security number 6773.
That's correct.
Okay, you have motions here today.
Yes, Your Honor, I believe, the Commonwealth filed a motion, regarding additional DNA testing, of samples that were taken and are now in custody of, Deputy State Police.
There was a swab and what else?
There was several more swabs that weren't consumed by the FBI in different places on the victim's truck. And I filed a notice that the Commonwealth wanted to test those items. I figured that since everything had been so litigious so far, I wanted to give notice. And that what I would propose doing is that we enter an order so the items can be sent to the Kentucky State Lab. And in that order state that that the lab get back with the Commonwealth and tell them what kind of testing needs to be done and whether it's consumption or not. And if it is consumption, we'll just have a hearing and see if the court will grant permission.
Well, I'll go ahead and grant permission, but I want to give notice to the defendants for them to tell the Commonwealth if they desire to have someone present when the tests are done. There's no law that they can't be tested or consumed. You just have to give notice to see if you want an expert witness there. Is that correct?
And that was, our position, Your Honor.
So is that okay?
I believe so. The position that we were taking is that sending it to the lab, of course, and seeing what testing would be necessary, because it may not even be necessary to consume everything. There may be sufficient items.
I'm pretty sure that when you had, here in this case before, that there were minute matters of DNA on some of them, and they have to put it all together and consume it. So let's just presume that they're going to be consumed, okay? So you need to, I'll give you, sign the order and give you 20 days to notify the Commonwealth of, as to when the dates that your people can be available, and see if we can coordinate that with the Kentucky State Police Lab, if they want to be present or if they can do it by Zoom, or what conditions would be okay. And I'm not going to put it out a long time.
I understand, Your Honor.
Just to be clear, I can draft an order then saying the items can be sent to the lab. They can be consumed if necessary, but they have to have notice where they can have their.
They should be held until.
That's correct.
They should be held before consumption until we get a notice from the defense counsel if they want someone present. And if they do want someone present, they'll have to have a timely date for that person to be present. Okay?
I think I can follow that.
Okay. You understand that, Mr. O'Donnell?
I do.
Okay, thank you very much. Okay. Let me run down through these few that I've got here. William Rowe. William Rowe. William Rowe. Commonwealth versus William Rowe, 23 CR 0022. Are you William Rowe?
Yes.
Born in 1985.
Yes.
Last four digits of your social security number are 6413. Is that correct?
Yes, sir.
We're here on a pretrial conference. What's the Commonwealth?
Judge, I was actually just discussing this case with Mr. Stockton. We had agreed, there's quite a bit of evidence, and some I just received on Monday. More than setting this on that June date, if the court would allow, we would want to ask to go up to that July 25th date for our next pretrial.
What's the negotiation dates you want?
July would be July the 5th.
Yeah.
Okay, negotiation day, July 5th, and where would that be located?
Be here.
In Cumberland County?
Or wait a minute, we're alternating back here. Okay.
Okay, July 5th for negotiation in Cumberland County, and July the 25th for the next court date. Both of them are conditions of Mr. Rowe's bond. And what's Mr. Rowe charged with completely?
Sexual abuse.
Okay, so if there's any change in condition, the bond will have to be by agreement of the parties unless you want to hear him.
Yes, Your Honor.
Okay. They've got some new information, Mr. Rowe, that your attorney wants some time to go over with you, so he'll be up to see you shortly, okay?
Yes,
Well,
sir.
not shortly, but yes. Okay, thank you. Commonwealth versus John. Commonwealth versus John Scott.
And Judge, he may actually be at the RCC. I think we've got the Class D facility.
Yeah, he's down there. They should be getting on. I let him know he was next.
Okay, we'll go ahead with Keith Smith, and when they get on, I think they're on there now. I see the other, are you down there at the other facility with John Scott? John Scott? The RCC? Or do you turn your camera on?
If he gets parole,
It's June first, so it should be running out.
we just need to pass this next month. That's what you want.
Okay, let's go on with Keith Smith. Will you call over there and explain to RCC again how to turn that camera on? It's usually a problem. Commonwealth versus Keith Smith. Are you Keith Smith?
Yes.
Born in 1963.
Yes.
Last four digits, social security number 8253.
8263.
8263. That needs to be noted on the docket. It's a change. We're here on 23 CR 0024 probation revocation. What does the Commonwealth have to say?
Your Honor, was placed on probation and started being supervised on March 19th, 2024. He has a 5-year sentence for possession of a handgun by a convicted felon and a 3-year sentence on possession of controlled substance, 3 years for a total of 5 years. He got a new misdemeanor arrest on April 18th, 2024 for DUI. He ultimately had to do a search warrant to get his blood, but on that same date, he admitted to Officer Garner that he'd used methamphetamine. So he was prepared for hearing if we need it.
I think we need to have a hearing, Your Honor, point of clarification from Mr. Stockton's statement.
Speak up just a little bit.
Point of clarification, Mr. Smith acknowledged use of methamphetamine 4 days before the DUI, but I do think we need to have a little hearing on this.
That's correct.
Okay, we'll pass it to the end of the docket today. We'll call you back up in just a minute, Mr. Smith.
Okay.
We'll go over to the docket. Commonwealth versus Melissa Thurman.
They're on down there at Class D now, whenever you
Okay,
want to go back to.
thank you. Let's go back to John Scott. Y'all turn your microphone on there. There you go. Can you hear us now?
Yeah.
Y'all say something. Okay, Commonwealth versus John Scott, 23 CR 0045. Are you John Scott?
Yes, sir.
Born in 1962.
Yes, sir.
Your last four digits, social security number 9063. Motion for shock probation.
Yes, sir.
Excuse me. I filed this last month. I wanted to preserve this issue. Mr. Scott actually comes up for parole June first, so he may get some good news, hopefully next week. So I would just ask to pass this pending the parole decision.
Yeah, what's your position gonna be if he doesn't make parole?
Well, I would be all right with shock as long as he has that matter in Tennessee taken care of. I don't know the status that he's got a felony arrest in
I
Tennessee.
think that has been, you done with Tennessee
Okay,
stuff.
I wouldn't have any objection.
Okay, well, Mr. Scott, it appears that, what's the date? It's gonna be
June first.
June 1st, you'll be in front of the parole board. It would be better for you to get parole than it would to get probated. You understand what I'm saying? So what they're saying is that they're gonna wait to see what the parole board does on June 1st. And Mr. Stockton said that he wouldn't have objection to probate you if you got the Tennessee matter handled. With drug treatment. With drug, and get some drug treatment, okay? So
Okay,
we'll
thank
just, they'll be talking to each other, and if you get paroled, you'll be finished with us. But if you don't get paroled, then they'll do an agreed order and send it to me under those conditions, okay?
Thank you, sir.
Okay, thank you. Good luck to you.
You too.
Yeah, let's go back to Melissa Thurman. Melissa Thurman. Melissa Thurman. Yes. Are you Melissa Thurman?
Yes,
Were you born in 1974?
yes.
Last four digits of your social security number 6854. That's the last four digits of your social security number 6854.
Yes,
You're here on 24 CR 0025 for arraignment. You weren't represented in district court by a public advocate. Can you afford to have an attorney?
yes.
You can't afford to hire your own attorney, you can't?
No, sir.
Okay. Do you have a job?
No, disabled.
Okay, you're disabled. Well, I'll go ahead and appoint the Office of Public Advocacy here. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you possession of controlled substance in first degree, possession of drug paraphernalia. You understand those charges?
Yes,
Counselor, you acknowledge the identity of your client who self-identified, received indictment, waive formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
What is Ms. Thurman's bond now?
15,000.
Ms. Bond, Ms. Thurman, do you have anybody that can sign your bond? How long have you been in jail?
week.
Yeah, do you have anybody that can sign a bond? It doesn't cost them anything. They just gotta come down here to the clerk's office and show that they're.
I have family. I may have some family there.
Well, who do you have that will sign your bond?
Lisa Birdwell. Lisa Ballard.
But she would be fine to sign the bond. She'd be fine, or another family member like that, come into the clerk's office and I'll pre-approve them, okay?
Okay, thank you.
By now, she'll need to be here on,
June 7th.
June the 7th. And for negotiations, that will be here in Cumberland County, right?
No.
You go to Clinton County on June the 7th. And on June the 27th, you'll be back here in Cumberland County. Okay, and your attorney, you need to get a hold of your attorney. If you'll call down to the clerk's office, they'll give you the number. You have a pencil and paper there?
No, sir, I don't.
Okay.
I wrote record dates down.
Okay, give her the Mr. Pennington's number. Do y'all have Mr. Pennington's number there at the jail?
No, we don't have his number.
What is your number?
It is area code 606-681-5299.
Okay, I got it.
That's Mr. Pennington, and that's your lawyer. If you'll call him, and as soon as you make your bond, give him a call, okay?
Okay.
Okay, thank you very much. Commonwealth versus Cody Willis for sentencing.
Good afternoon, Judge Ryan Roby here from Mr. Willis.
Okay, thank you. Are you Cody Willis,
Yes, sir.
born in 1989?
Yes, sir.
Last four digits, social security number 2394.
Yes.
And you're here on 23 CR 0040 for sentencing. Mr. Willis, have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct?
Yes, sir.
Is there any reason that this gentleman should not be sentenced today, Counselor?
No, Your Honor.
Upon a plea of guilty, convicted felon in possession of a handgun and a persistent felony offender second, the defendant shall receive a sentence of 15 years. On a plea of guilty to possession of controlled substance, first degree fentanyl, he shall receive 3 years. On a plea of guilty to theft by unlawful taking firearms and PFO, he shall receive a sentence of 10 years. Upon a plea of guilty to theft of identity of another without consent, 2 counts, 5 years. On each count to run concurrently for a total of 5 years. These sentences are to run concurrently, all of them, for a total of 15 years. Serve 330 days in jail and probate the balance for 5 years. Probation is to be supervised. He shall receive credit for 153 days in jail and 139 days of home incarceration. He shall have no contact with the victim. He shall pay as condition Junior Smith for $190 for home incarceration, and he will enroll and complete SPRC, the Spark Rehabilitation in Russell County, for a minimum of 6 months. Upon his release, he should go immediately to Spark and shall not leave without permission of probation and parole office. What are the court costs in this case?
$215.
200 and what?
15.
$215 court costs, and you don't have to pay that until you're finished your rehabilitation, and then you can pay it at $50 a month to get it paid.
Judge, there is one item. They have updated the custody time credit and sent that over.
It'll be adjusted.
Okay. That would mean his release date would be today. Spark has someone that can come pick him up. I just wanted to make sure that I wasn't sending him there.
Wait just a second. Let's make sure that probation and parole verifies that. And you're talking about from the day that was signed through today would get him beyond the period. Is that what you're saying?
Correct, Judge.
Is that the only additional days from the date the plea agreement was signed to today, or has there been some other adjustment?
There was another adjustment that was emailed from Miss Bethany Foley Bell to Miss Thompson on May 15th at 4:38 p.m. Judge.
Your Honor,
You'll come up where we can hear you.
Your Honor, Junior Smith finally got back with Officer Foley and provided her with the legitimate dates of the ankle monitor, and he has acquired 331 days credit. She emailed everyone a updated custody time credit sheet that reflected those dates.
Okay, well, when Spark, then he'll be given the credit for those days that were updated. And when Spark gets ready for bed, are they going to come over and get him?
They have someone on standby to hear from me, Judge, on whether to go pick him up today.
We'll get the order signed and up there. Okay.
Thank you, Your Honor. That'll conclude our business.
Wait a second. What? Do what?
It's supposed to pay Junior Smith $190 cost sentence, but I'll motion that.
Has he paid the $190 by sentencing to Junior Smith?
He did, Judge.
Okay. Well, we'll get the order up there and you'll get a copy of it. When you get a copy of this electronically filed order, you can call him to come over and get him. Okay.
Thank you, Judge. That'll conclude our business.
Okay. Y'all excused.
Thank you.
Pauletta Wilson. Commonwealth versus Pauletta Wilson, 24 CR 0019. Are you Pauletta Wilson?
Yes.
You born in 1974? Were you born in 1974? Yes. Last 4 digits, social security number 5611.
Yes.
Okay, we're here today for a pretrial conference. What do we have?
Felony plea, Your Honor.
Miss Wilson, I understand that a motion has been filed says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Is this plea freely and voluntarily given?
Yes.
Okay, are you the same person we just identified just a minute or two ago in 24 CR 00019?
Yes.
Is your judgment impaired in any way today? You understand what's going on?
Yes.
Have you discussed this charge with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
You believe that you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything, and a right to a speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel their
Yes.
attendance. You have a right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove it on a reasonable doubt that you're guilty. You understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from the place below. In the event that I do not accept the Commonwealth's recommendation, say impose a harsher sentence, you have the right to withdraw your plea of guilt. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. The defendant shall receive credit for time served. The defendant agrees to be assessed by the social services clinician and will follow any recommendations thereof. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that your understanding, ma'am, of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts as charged in the indictment?
Yes.
Okay, are you doing so of your own free will?
Yes.
Knowing your constitutional rights, I explained to you, is it still your desire to waive those rights and enter a plea of guilty and allow the court to fix your punishment within the range you agreed to?
Yes.
You understand that by entering guilty plea today, if you have any future felony convictions in the future, they could be enhanced so you could be charged as being a persistent felon offender. You understand that?
Yes.
Is that your signature right there
Yes.
on that line?
Yes, sir.
I'll accept the plea. Order pre-sentence investigation report to be done by probation and parole. Set the sentencing.
And Judge, if I
Wait
may,
just a second now. Set the sentencing for June the 27th. Now, what would you like to say, Mr. Pennington?
and Judge, it was particular to that point. Judge, Ms. Wilson has been incarcerated for some time.
Is she gonna be probated on this charge?
She is, Judge, and she's
How about me letting her out till sentence?
letting her out until sentencing.
Yeah.
That's what I was gonna ask for, Judge.
Well, you didn't even have to ask for it. See, you got. I don't know. I don't know. Since you didn't ask for it in time, we might not.
Come on, Judge.
Yeah, did she have somebody make her bond previous in district court? How much is her bond?
District court, she had AR. 15,000 surety, it's been inserted the whole time.
Okay, well, I'm gonna just let her sign her own bond to be here.
Thank you,
Yeah,
Judge.
she's in her plea. You sign a bond up there and you be back here. You need to meet with probation and parole. When can she meet with?
She's released today, she can come today, Your Honor.
Can you be released today? Have somebody bring you over there to the probation and parole office to take the information. And then you can be on your way rejoicing and be back here on June the 27th at 9 a.m. for sentencing, okay?
Okay.
Would you like? I'm sure.
Yeah, you need to stay at, you can go to work, church, or the doctor until then, okay? You
Okay.
don't need to be say in Monroe County, you don't need to be out of gammon around, you know what I'm saying?
I know I have a
Okay.
lot, I don't drive.
Okay, okay. Now,
Thank you.
is there anybody else, is there anybody else in the Adair County Jail that needs to see us?
Do they have Robert Young?
We do, yeah, I've got him ready here.
See on,
We've actually used with Casey County.
oh yeah, the other Robert, yeah, Robert almost slid by there.
We've also got Keith Smith there too, verification.
Yeah, we're gonna have a hearing on him.
And the grand jury.
Okay, I'll do the grand jury after we do Mr. Young. Are you Robert Young?
Yes, sir.
Were you born in 1978?
Yes, sir.
Last four digits, social security number 3613.
Yes.
We're on 22 CR 0025 and 24 CR 0020 for a pretrial conference and a probation revocation. What do we have?
Judge, we have a plea on the most recent charge, and Mr. Young will be going into specialty court in lieu of verification.
Well, let me just take the plea first, okay?
Yes, Your
A
Honor.
motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes.
Currently under the influence of drugs or alcohol,
No.
plea freely and voluntarily given.
Yes.
Are you the same person that we just identified in 22 CR 0025 and 24 CR 0020?
Yes, sir.
Are you impaired today, or you understand what's going on here today?
I do understand.
You discuss these charges with your attorney. Are you satisfied with his advice?
I am.
You have you viewed the evidence Commonwealth has against you? Are you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea of guilty, I need to know that you understand those rights. I want to go down through it, and then at the end, I'm going to ask if you understand. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, have process issues to compel their attendance. You have a right to appeal this matter to higher court. If you lose, you have to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. You understand that by entering a guilty plea, you give up those rights. You understand that? I may consider the Commonwealth's recommendation, but I may accept any range of sentence provided by law. I don't have to accept any recommendation. Prior to accepting a recommendation, I'll await the pre-sentence investigation report, probation, and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence on you, you'll have a right to withdraw your plea and go to trial. Do you understand that?
Yes,
Ms.
sir.
Gordon Anderson, what's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance first degree, the defendant shall receive a sentence of 2 years, probated for 5 years. Probation is to be supervised. This sentence is to run consecutively with Cumberland Circuit Court case number 22 CR 25. The defendant agrees to enroll and complete the Cumberland County Specialty Program. The defendant shall be released at orientation, but not prior to final sentencing. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. And the defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agreed to, sir?
Yes, sir.
You are pleading guilty because you committed the acts charged in the indictment as amended.
Yes.
Knowing the constitutional rights explained to still your desire to allow the court to fix your punishment within the parameters allowed by law. Is that true? You know, you're entering guilty plea, you know that any future convictions you have as far as range and penalty could be increased because of persistent felony offender law. You understand that?
Yes, sir.
Now, is this your signature on here? There, that's your signature?
Yes, sir.
Okay. I'll accept the plea order, pre-sentence investigation report done by probation, parole, sign the referral to drug court. You'll be here on June the 27th for sentencing, and then if you're approved for drug court, shortly thereafter, if you've been approved, they'll do an interview and get you orientation, and I'll let you out just as soon as they can get you oriented, okay?
Yes, sir.
Thank you.
Thank you, Judge.
Now, we're gonna take about a 5-minute break here before we come back to have the hearing that we're supposed to have here.
Do you all
I
still need
understand.
Keith Smith? I know
Yes,
you,
we'll take about a 5-minute break before Keith Smith.
okay,
Maybe a 4-minute.
okay.
Now, let's go off the record and then I'll come back and do the answer.
Is Tom Shay still here? I sent him a text. He must not read it. It's all right.
He said visiting Bill and.
Oh, okay. That's long.
Yeah, I got a little sick. You know that, guys, and.
We're eating or something.
Yeah, she went there, picture says that you can see a video part of the diversity program. So yeah, there's is pretty big.
You don't know what friends.
Nowhere. Slime green is just natural and fresh. Thanks for me. Yes, it was all same special. Thank you, sir.
It's hard being something. So it's hard to cross. You already did that.
Have you been to see the all?
It's really.
I think it's Wednesday.
Oh, yeah. He looks like one of those.
He does. He's reaching out. Yes,
I think you have big planes on a lot of this. This thing kind of go with the same issues. And,
Let's go back on the record, please. Mr. Bailiff, will you get the grand jury, please? We're on the record over there, so if y'all want to read what you say in the newspaper.
I done messed up there, Judge.
Well, expectations weren't real high, so. Go off the record. Did they go get the grand jury? Did y'all tell the grand jury to come on out? Hell, yeah.
All rise from the grand jury.
Oh, sorry. Okay, everyone be seated. Madam Foreperson, have y'all completed your work?
Yes, Your Honor.
Did 9 or more of you sign the document?
Yes, Your Honor.
Okay. Okay, well, everything appears to be in order. I'll go ahead and sign the documents. Either issue, if the people are in custody, probably issue summons for them. If they're not in custody, we will do warrants, sit bonds sufficient to protect the public and to assure their appearance here in court. You are next to be here on June the 27th. Hard to believe that this year will be over half over already, but that's the way it goes, isn't it? Okay. Thank you very much for your service. I want to remind you that you should keep everything that you've seen in the grand jury or heard in the grand jury completely confidential. Some of it's a very sensitive nature. And we'd appreciate you keep that under your oath, okay? Y'all can be excused. You can be let out, Mr. Bailey, if you let them go out this way here. We'll see you then. Let's call back in because of riot, insurrection, or special grand jury. Okay, let's go back to Mr. Smith in Barron County. Y'all are up directly after Mr. Smith here. Where's Mr. Cross? Commonwealth versus Keith Smith.
Yes.
I call Hunter Tweedy wrong.
Hunter Tweedy.
May I stand at her so I can hear well, Your Honor?
Sure.
Thank you.
Officer, you raise your right hand. You swear the testimony about to give us the truth, the whole truth, nothing but the truth.
I do.
Have a seat there. Mr. May inquire, Mr. Stock.
Where are you employed, officer?
Burkesville Police Department.
Did you have an encounter on April 18th, 2024 with Mr. Keith Smith?
I did.
And can you tell the judge what happened?
On, did you say the 17th?
The citation says April 18th. I don't know if that's correct or not.
My citation saying it's April 17th.
Okay, I'm talking about the probation report, so yours is correct. Go ahead.
Yes, sir. On that day, I observed the above subject, Mr. Keith Smith operating 2002 white Chevy Silverado. I ran the registration plate to that vehicle, and Mr. Smith's operator's license was attached to that registration information. I observed that his license was suspended. I made contact with Mr. Smith at the car wash on King Street by Dollar General. Upon contact, I confirmed his identity by asking if he was Keith Smith. He advised he was. I asked him that I advised him that his license was suspended. He advised me that they were not. I then asked Mr. Smith if he had an interlock device. He advised he did not.
Why did you ask if he had an interlock device?
I believe one of the restrictions on his license information said that interlock device requirement.
Okay, I just want to make clear. So he didn't have a valid license?
No, sir, he was suspended.
Suspended, but he didn't present you a license that said he had to have an interlock device?
He didn't have a license at all, I don't believe.
Okay.
I don't recall.
Okay, well, go ahead then. What happened then after you asked him about that?
I advised him that his license was suspended. He advised to me that they were not. I then asked if Mr. Smith had an interlock device. He advised he did not. I then asked for Mr. Smith's license, which he provided. He did have a license.
Okay.
I advised Mr. Smith to stand by his vehicle, or I ran his information through dispatch. Dispatch advised that his suspension order expires 9/19/24. While I was gathering this information from dispatch via radio, Mr. Smith did not follow my instruction to stand by his vehicle, and he sat back in his driver's seat. Trooper Brandon Poole with Kentucky State Police Post 15th arrived to assist with the traffic stop. Upon speaking with Mr. Smith again, he had slurred speech and he was hard to understand. Trooper Poole requested to look at Mr. Smith's eyes to see how they react to the presence of light. When light was presented to Mr. Smith's eyes, they would constrict and then dilate as if his pupils were pulsating. Trooper Poole then requested Mr. Smith to count backwards from 58 to 46. Trooper Poole had to stop Mr. Smith at 31 due to counting backwards past 46. Trooper Poole requested Mr. Smith to tilt his head back and count to 30 in his head with his eyes closed. While doing so, Mr. Smith had body tremors in his eyelids and his hands. I then proceeded to check Mr. Smith using Stanford field sobriety tests. He showed 0 out of 6 clues for HGN, 5 out of 8 for walk and turn, 4 out of 4 for one leg stand. While instructing this test, Mr. Smith was having a hard time following my instructions and I had to repeat multiple times. Due to the totality of circumstances, I believe that Mr. Smith was under the influence and not safe to operate a motor vehicle. I placed Mr. Smith under arrest and transported him to Cumberland County Hospital to request blood. Mr. Smith's vehicle was towed by Long's Record Service and I read implied consent to Mr. Smith and requested blood and urine. Mr. Smith denied consent for both. I applied for a search warrant affidavit for full whole human blood, which was signed, and I executed that search warrant. And at the Cumberland County Hospital, and the sample was sent to KSP Lab.
Okay, so your opinion was Mr. Smith operating that vehicle while he was impaired?
Yes, sir.
Okay, I don't have any other questions for this witness, Your Honor.
Just a few questions, Officer Tweedy. You didn't stop Mr. Smith for any reason other than you ran his plates and you found out that Keith Smith's license was suspended. Is that correct?
Yes, sir.
No bad driving, nothing like that, correct?
No, sir. Just suspension.
And did Keith appear to be a bit hard of hearing to you? Is that why why do you believe it was hard for him to understand?
I don't recall.
Okay, so, okay. Now, you stopped him for driving unsuspended. Were you planning on arresting him or just writing the ticket on that?
I don't recall.
You had the discretion to do either, is that correct?
Yes, sir.
Yeah. Why did you not just do that and then let him go on his merry way?
Don't recall. Just trying to investigate further, see if he was under the influence.
I'm sorry, sir, I did not hear you.
I was investigating further to see if he's under the influence.
Why were you doing that, sir?
Because he was having troubles following my instruction.
That's fine. And drug screen's not back yet, is that correct?
I haven't checked yet on the piece of camera.
I'll tell Jeremy Garner.
Okay, step down.
He may excuse.
Yeah, you can be excused. Thank you, attending officer. Swear the testimony about to give the truth, the whole truth, nothing but the truth.
Yes, sir.
See.
Officer Garner, did you have any contact with Mr. Smith on it?
Identify with whom he's with.
Oh, I'm sorry. Who are you employed?
With probation and parole.
Now, Officer Garner, did you have any contact with Mr. Smith at or about the time he was arrested for the DUI?
Yeah, I was notified the day after his arrest on 4/18 that he was arrested. I went to the Adair County Regional Jail, met with him, and I requested a urine sample. At that time, he admitted to signing an admission of guilt form for the use of methamphetamine occurring on or about at the mission form right here. 4/14, he said he used three times that day, 4/14/24.
Okay. I have no other questions.
Garner, if the only issue Mr. Smith had would have been use of methamphetamine, and let's not consider the DUI, would you have sanctioned him, or what's your usual course of doing business in that regard?
In terms of if he just had the positive test,
Yes, sir.
I would refer him to the social service clinician, depending on how many positive tests he had, which I don't have it in front of me at this very moment.
Had he been compliant up to that date? I know he hadn't been on probation long, but.
He hasn't been on probation long enough for me to really assess that any other additional issues yet.
Okay. Does Mr. Smith appear to be a little slow or hard?
I've never encountered any issues with him in terms of his comprehension or hearing.
And just point of clarification, his use of methamphetamine predated his arrest by 3 or 4 days. Is that correct?
Objection. He admitted he used it that day, but I don't know.
No, he admitted, but it's on the form.
I agree that that's what he admitted to.
You agree to what?
I agree that's what he admitted to. That he said he used it 4 days before.
Okay, you stipulate 4 days. Yeah, that's all. Thank you.
One question. You only started supervising Mr. Smith on March 19th, 2024, did you?
I believe that's right.
Okay. Had you met with him other than the one time when you initially signed him up?
I have to refer to my records. I believe that he reported for intake and that was it.
Did you drug test him that day?
I did.
Okay.
I'd have to look at my records to give you the results of that.
Okay. So you don't know whether he passed or failed that day?
I don't believe that he failed
Okay.
off the top of my head.
Be excused.
I have no other reasons.
No witnesses, Your Honor. I don't think American Key testified.
What do you have to say?
Well, the reason I brought this case, Your Honor, went ahead and filed the motion is because it's a DUI. He wouldn't cooperate with the officers. He wouldn't consent to a blood test. And then they had to go get the search warrant to draw his blood. And I think he was pretty smart at the time, admitting to the use of meth 4 days before instead of letting Mr. Garner go ahead and test him the day after, but that's neither here or there. But if he's not revoked, he doesn't need to be out running around. He needs long-term treatment somewhere because you just can't go out and drive without a license DUI and be impaired. And the only testimony we've got today is of the officers. In his opinion, he was impaired and he wouldn't consent to a test.
Briefly, Your Honor, I feel a bit bad about this because it's obvious Keith did not understand that his license was in fact suspended. And perhaps.
What makes you say that he didn't understand?
Well, he told the officer his license wasn't suspended. It's all.
Well, that doesn't mean he didn't understand. He could have been lying about it.
Well, that's true.
Now, I've known Keith. He's not much of a liar.
That's right.
You know, I mean.
Right. But here, let's step back.
We can't presume he didn't know it though.
If he only had a bad test, then he'd have been sanctioned or referred as a clinician. He wasn't stopped for being under the influence. He was stopped for driving on suspended. He had something in his system, obviously, because he admitted it.
Where is the DUI in this? Is it the district court now?
Yes, and there's no blood work back or anything yet.
Okay.
Your Honor, you know Keith better than I do. He's raised here in Burkesville and he's really messed up on this. I'm asking for a sanction at this point.
Well, the problem is, I do know Keith. I've known his family. I've had affection, especially, for his grandmother, I guess, and everything, but his mother. But that doesn't mean that he can go around when he's out on probation, taking meth and driving a vehicle. Now I'm gonna take the revocation under advisement till we see what happens on the DUI. And then with the time he spends between now and then, the Commonwealth can take a look at it. I'm not gonna revoke him today. Okay.
You're not revoking and you're not letting him bond out, is that?
That's correct.
Okay.
I'm gonna let him stay there and maybe get some time in. It'll count toward whatever we end up doing. And if we revoke him, it'll be good time. And if we sanction him, it'll be time. Okay?
Thank you.
Okay. Okay, thank you very much. Dare County, do y'all have anybody else before we go to Barron County?
No, that's it.
Okay, thank y'all very much. Let's go to Barron County. Barron County. First, is Barron County on the line? Barron County. Barron County, are you there? Barron County.
Yes, Your Honor, we're here.
Okay, well, first, let me apologize to y'all for having to do this extra day to the attorney that wasn't able to be there because of the trial, but thank you for your cooperation. Y'all very cooperative always. Do we have Richard Armstrong first? Richard Armstrong. Commonwealth versus Richard Armstrong. 23 CR 0080. Are you Richard Armstrong?
You gotta talk.
Are you Richard Armstrong? Say something, Mr. Armstrong.
Yeah.
Okay. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Have you reviewed that with your lawyer?
Gotta talk.
No.
Mr. Bell? Is this your client?
No.
Where's Mr. Pennington at?
believe he may have left.
Would you like me to call him, Judge?
Well, he doesn't have Monroe County anymore.
No, it would be.
This is
He owns this,
It's a Cumberland County case.
This is a Cumberland County case, had Monroe County case. Get Mr. Pennington on the line.
let's see.
I guess that's why I got confused.
Yeah.
Well, let's pass over Mr. Armstrong until we find his lawyer here, and we'll take Stephen Brown.
Yes.
Caldwell versus Stephen Brown. Are you Stephen Brown?
I am.
Okay, this is 23 CR 0063 and 24 CR 005. Were you born in 1980, Mr. Brown?
Yes, sir.
Last four digits of social security number is 0396.
Yes, sir.
We're here for a pretrial conference on 23 CR 0063, 24 CR 0005. What does the Commonwealth have to say?
Have a felony plea.
Mr. Brown, a motion's been handed to me, says that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we identified just a minute or so ago in these two felony cases?
Yes, sir.
Is your judgment prepared today in any way?
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with his advice?
I am.
Have you reviewed the evidence which the Commonwealth has against you, and you believe you're fully, that's your case?
Yes, sir.
This Monroe Circuit Court meeting by agreement here in Cumberland County, you have certain rights under the Kentucky United States Constitution. You understand that you do not have to plead guilty today, and I'm going to go through those rights and then I'm asked to see if you agree to waive those. You have a right not to testify against yourself. No one can make you say anything. No one, you have a right to speedy trial. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called and testify against you. Right to produce evidence, right to call witnesses in your favor. Your right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand by entering your guilty plea today, you give up those rights. You understand that?
I do.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
I do.
Madam Commonwealth Attorney, Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to indictment number 24 CR 5 for the charge of criminal possession of a forged instrument, second degree, 2 counts, the defendant shall receive a sentence of 5 years on each count for a total of 5 years. Upon a plea of guilty of indictment number 23 CR 63 for the charge of fleeing or evading police first degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to indictment number 23 CR 63 for the charge of criminal mischief first degree, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run consecutively for a total of 5 years. 5-year sentence.
Wait.
Oh. The 2 5-year sentences shall run consecutively for a total of 10 years. Sorry. The 5-year sentence in indictment number 24 CR 5 and the 10-year sentence in indictment number 23 CR 63 shall run concurrently for a total of 10 years. Serve 180 days in jail with the balance probated for 5 years supervised. The defendant shall enter and complete a long-term treatment facility for a minimum of 6 months scheduled and enrolled through his attorney and subject to the agreement of the Commonwealth. The defendant shall be released from incarceration the morning of the bed date, and the defendant shall be transported from the jail to the treatment facility by probation and parole. The defendant shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained, and the defendant agrees to have any and all evidence disposed of in accordance with the laws of the Commonwealth and of the holding agency.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did indeed commit the acts charged in the indictment as amended?
I am.
Are you doing so of your own free will?
I do.
Knowing your constitutional rights, still your desire to give up those rights, enter a guilty plea and allow the court to fix your punishment.
I do.
You understand by entering this guilty plea today, these future convictions could be used to enhance your range of penalty under persistent felony offender law. You understand that?
Yes, sir.
Will you get the plea there and hand it up here?
I've got a letter here. Can I send it with you to the judge?
Well, you can send anything you want to, but I want to look at the plea.
Yes, sir.
Is that your signature on there, sir?
Yes, sir.
Okay, will you date this, counsel?
Yes, sir.
Okay, you sign it. And what's the purpose of that, of this letter you sent me up here? What is the
That's
purpose?
part of the plea agreement, Judge.
You want it attached?
We just
You
showing.
want it attached?
Yes, sir.
Okay, go ahead and date that. Okay, I'll accept the plea agreement or a pre-sentence investigation report done by probation and parole. And is it June the 20th? Is that the date Monroe County Commonwealth Attorney is June the 20th?
Yes.
And these documents will be taken back over. Ms. Anne Marie Gordon, are you going to take these documents back over to Monroe County? Okay. Okay, well, probation and parole people will come up to interview you, so we'll make sure that you get the pre-sentence investigation report done by the 20th, and then they'll soon thereafter, as they can, line you up a bed date. Okay?
Yes, sir, Judge.
Okay, thank you very much. Next is David Buck. David Buck. Are you David Buck?
Yes, sir.
This is 24 CR 0017 Monroe Circuit Court. Mr. Buck, were you born in 1982?
Yes.
Last four digits, social security number 2125.
Yes.
Okay, we're here today on a pretrial conference. What does the Commonwealth have to say in this case?
Mr. Bell and I have discussed this. We need one more negotiation day. I'm not sure.
Okay, will that be on July the 5th?
June 7th.
June
June the
7th.
7th? June the 7th in Tompkinsville?
Correct.
June the 7th for negotiation in Tompkinsville, and the next court date would be June the 20th in Tompkinsville. And what's Mr. Buck charged with?
Fleeing and evading.
DUI.
Two counts, police officer fleeing, evading first, reckless driving.
Okay, thank you very much.
Judge, we would ask you to consider amending Mr. Buck's bond. I understand the court's position concerning DUIs, Your Honor, but this is somewhat of a anomaly.
You can discuss with the Commonwealth.
Well, I've already done that.
Whether they're not willing to do it, there have to be a hearing on it then. If you want to schedule a hearing on bond reduction, we can.
Well, if we can't get him out of jail, Judge, I'd just assume set this thing trial, pull the trigger on it. Let's get it done.
Whatever you want to do.
That suits me.
I don't know anything about the case, but I can't just agree to do a bond where you come up here not filing a motion and me knowing anything about it. I'm willing to consider a bond if it's appropriate, but we'll set him a trial date then.
Well, I'll get the bond trial, Judge. I apologize. I just feel sorry for Mr. Buck. He missed his graduation with his little girl. A lot of everything. You know how life is.
Listen, I have empathy for people too.
Sure, I know.
Not only sympathy, but empathy.
Yes, sir.
you know, but, I can't do anything about it. I didn't, until we find something out. Okay,
We'll get something out.
okay, that'd be good. Okay, Gary Hall. Did y'all get Mr. Pennington? Is he on his way back?
He's not here.
Y'all ready to dismiss?
He was there longer.
I think he was set for trial. one day.
Gary Hall.
Yes, Your Honor.
Judge
This is come over as Gary Hall, 23 CR 0040. And we're here, it says, on a pretrial conference for that. And then there's an additional indictment, which you have a PFO. Is that
That's
correct?
correct, yeah.
You have a copy of that for me?
I don't think I brought the file.
On your
I
green.
was right on and I didn't get it. The late history night, I didn't overlook it when I saw Mrs. Megan's document.
Well, Mr. Hall has an additional, subsequent superseding indictment charging him of being a persistent felony offender, which we can provide to you. Don't have it here today. If somebody will call the clerk's office over there now at Monroe County and have them to fax it or electronically file it.
I can get that.
Well, okay, so you acknowledge the receipt of the indictment, at least constructively, enter a plea of not guilty, reserving all pretrial motions for Mr. Hall. Now, do y'all need a conference day on this?
This was one that was set for trial and he showed up unfit for trial. So I don't know how long the court wants him to serve. If you want us to have another pretrial, we can. I don't know if,
What's the underlying charge? What's the underlying charge?
He was accused of shooting his significant other in the hand or wrist. And there was 3 people there, her brother, and Mr. Hall. Her brother is now deceased. And the victim gave a statement outlining how Mr. Hall did it, and then she went to Mr. Bell's office in their county. So that's pretty much the case.
Well, he has one of those benches there that he allows his mourners benches.
Yeah. They come in and have prayer, I guess. So
Yeah.
I'd be willing to do a split sentence on it if it's something the court would entertain, but there's a gun at issue and a fire, and a discharge of a weapon, so.
Yeah. And so he showed up unfit on the day of the trial?
Yeah, he was intoxicated the day of the trial.
You recall that, Judge.
I'm just getting in the record.
Impaired, I guess.
Put it on the record.
Well, let's just, if you offered him a plea agreement?
Well, I think under the circumstances, if the court would agree, I think he probably needs quite a bit of time hung over his head, a split sentence and long-term treatment. It's kind of what I'm thinking, if he wants to do that. And Mr. Hunley would probably be more upset, but I get to overrule Mr. Hunley.
We were trying to get that direction when we were going to trial, Judge, but we just never could come to an agreement. So I think we're closer now than we've ever been, especially if you've already got some time in.
That's going to help matters.
Yes, it is.
Well, let's schedule him to be over there on June the 20th and have a negotiation day on
June 7th.
June the 7th. Mr. Hunley can have another bite at the apple that way.
Yes, sir, Judge.
And we'll set him a trial date. If you can't reach an agreement on June the 20th, we'll set him a trial date. And we'll make it sooner rather than later, if you understand. So he's not losing any time by waiting between now and then.
Yes, sir.
Okay, thank you very much.
Thank you.
Make sure you get a copy of that superseding indictment, I guess.
Yes, sir.
Christopher Sutton. Christopher Sutton.
That's mine, Judge.
Are you Christopher Sutton?
Yes, sir.
Were you born in 1995?
Yes, sir.
Last 4 digits, social security number 1321.
Yes.
This is Monroe Circuit Court Case 24 CR 0007. Represented by Mr. Bell. This is a pre-trial conference.
Judge, I just, please, before I got involved in this case, I'd ask Mr. Stockton for another pre-trial on this.
July the 5th for a negotiation. June the 7th for negotiation and June the 20th for next court appearance. What is this gentleman charged with?
He's charged with possession of methamphetamine, criminal trespassing, unauthorized use of automobile, theft, unlawful taking, and in possession of a firearm at the time of the offense.
Okay, well, we'll just have to have negotiation on that, and,
Yeah, I'll do that.
if you want a bond reduction, you'll have to say.
We've got an agreed order on the bond, 10,000 cash or 20,000 property if the court will agree with it.
Tell me about the fire, tell me about the firearm.
He was in possession of a stolen trailer, and he had a pistol, and he had meth up in the butt of the pistol.
I don't know a lot about the case, Judge.
That's the facts it's told to us, but officer.
I have went and talked to him. We've not got full discovery on the case just because I'm just getting in. He has been in jail now for a substantial amount of time. I was somewhat surprised he'd been in that long. I contacted Mr. Stockton about getting.
I want the usual curfew restrictions.
So we would abide by any restrictions that you'd want to put on.
What kind of felony did he previously have?
Knew it one time. Yes. He's only got 7 cases on his criminal history, which is not too many in this day and age. He had a F case possession back in 19 and that was dismissed. He had a F case in 17 and that was dismissed. That one was in Monroe. The other one is in Barron. And he had another F case in Monroe dismissed in 17. He had a misdemeanor. So I don't think he's ever had a felony case. He's never got out of district court. That might be part of his problem. If somebody sent him on circuit court, he might not have gotten this kind of shape.
I don't think he had a felony, Judge, from my.
Yeah, he's had several felonies, but they've all been dismissed.
So he had this firearm that he had, this handgun that he had.
It's just that he was in possession of that at the time he was in possession of the trailer. He wasn't a convicted felon.
Okay, well, since he's not a convicted felon and he's not been proven guilty, the other thing, I'll go ahead and agree to this 10,000 or 20,000 with the restrictions on it. He's to be released. He's go to work, church, or the doctor. Anything else, he'll have to get permission of the pretrial or notify the pretrial folks that he's got to go somewhere of importance.
Thank you, Judge.
Okay, you want, Ms. Gordon Anderson, you want to take this bond back with you? Now, is there somebody else? We've got Richard Armstrong for sentencing.
Judge,
Barry
I'm back.
County.
My apologies.
Is that the last person, Richard Armstrong, the last person you have, Barron County?
Yes, Your Honor.
Let's get Richard Armstrong. His attorney is online here, Mr. Pennington.
Armstrong.
Now, previously, we had identified Mr. Armstrong and Mr. Pennington. He had some reservation as to whether or not he'd gone over this pre-sentence investigation report. Do you remember going over it with him?
Judge, I had sent that to him. So we've not went over it together. No, we have not, Judge.
Well, I'm not, we're not going to be able to sentence him today. Somebody has to go over it with him and review it with him. He's not willing to say that he reviewed it or that he's seen it. It seems a little out of it in a way. So we're going to have to reschedule. What's the next Monroe County rule day?
June 20th.
We'll reschedule his sentencing for June 20th, okay?
Yes, Your Honor. Or Judge, it has to be a Cumberland. It'll be
Wait. This is a Cumberland County case. The confusion was that he was in Barron. It's a Cumberland County case, so it will be set on June the 27th. Unless you find some reason that he needs to be sentenced sooner than then, that we could find him a place in one of the other counties, okay?
Yes, Judge.
You understand that, Mr. Stockton? Because it might not be the defendant's fault that he hadn't.
He wants to say it earlier.
Yeah, if you want to go over it with him and set it earlier, okay?
Yes, Judge.
Okay, is Mr. Bell gone? Did he leave? Okay. Okay, well, if that's all you have, Barron County, and I'm gonna send an order that Mr. Bell will deliver y'all a fruit basket over there for making you work an extra day. So, okay, but thank you for your cooperation, okay? See you later. Here's this pre-sentence investigation report. Send it back to our office here on that. Is there any other matter to come before the court?
Your Honor, we've got somebody from Vernon to submit herself as a possible surety for Kelly Scott.
I can't hear what you're saying. I'm sorry.
Court was going to review the bond of Kelly Scott. Pretrial says he's zero, the lowest, and we've got a landowner over in Vernon.
What case is this? Is it on the docket?
Yes, Your Honor. Remember, he was the one that had been indicted but hadn't been served. We had him come on up.
Yeah.
Live in Clay County.
Yeah. Got you. Is that a Cumberland County case?
Yes, Your Honor.
Michael Scott.
No, Your Honor. Kelly Scott.
See.
He's on the out as you, it's number 10. Front page.
See.
He's number 11.
Number 11. It's changed. Number 11. Okay. I was looking at 10. Okay. Okay. Who do you have sign the bond?
Wayne Watson. Watson, would you stand?
You come around, Mr. Watson.
Your Honor, we have.
Now, is Kelly Scott, has he been that's fine. That's good.
I was cleaning the house and doing laundry.
Well, I mean,
He's already been transported.
he's already been transported. You own property in Cumberland County?
No,
In Monroe County?
Monroe County.
Near
yes,
Vernon?
Vernon.
Yeah, near Martinsville.
Pardon me?
Martinsburg, near
He's
Martin.
across the river. Martinsburg.
Yeah, okay, I know. What was the bond set for you? 15,000 surety. So you have, your property's worth more than $15,000.
That's so, yes.
Yeah, okay. Well, I'll approve him to sign the bond, but is Mr. Scott, is he a Tennessee native?
I believe he's from Clay County.
Well, so he'll need to sign a waiver of extradition. And we usually do that here. So if you send a waiver of extradition form up there for him at the jail and tell him to sign that. And send it back down here and you'll acknowledge that he'll sign a waiver of extradition.
Absolutely.
And can this gentleman sign the bond here so he won't have to go to Monroe County? They'll accommodate you here. It's court approved. And if you go down to the clerk's office, they'll show you how to do it. And his appearances then would be on June the 7th for negotiation and June the 25th.
We've been saying 27.
27th.
Cumberland County case.
27th. Yeah, it's a Cumberland County case.
Thank you for that.
And the seventh is in Monroe County for negotiation.
It's in Monroe County for all, June 7th is all for
Yeah,
negotiation.
Monroe County's June the 7th for negotiation. You understand? Okay, thank you very much. Okay, that concludes the business of the Cumberland Circuit Court. Go off the record, please. Okay. Okay, let's go to the child support document. Mr. Coleman Hurt here.
He is, he's in the hallway, I believe.
Hey, let's go to the child support docket. Colby Evers versus Casey Jones.
Judge, a wage withholding is now in place on that one and it is now current, so I'm just asking for future review.
Pass over.
Yes, that order tender.
Backsmith versus Backsmith. Bach. Yes.
Parties are here on this one, Judge.
Okay, you want to bring them around?
Evans, Foxborough. Judge, we were here last.
Wait a second, please. Okay.
I'm sorry, we were here, earlier and she was, ordered to pay, on her arrearage by today, or else I was asking for an order of arrest. She has not paid. The last payment she has made was, I think in January. Does that sound right? So I'm asking her to make some payment this week, or else I'll be asking for an order of
Well, how
arrest.
much, what's the last order say?
Let's see. She was to purge herself. I believe it's 250, Judge. Yeah, or else contempt, and that has not been paid today, as of today.
What do you have to say, ma'am?
I just got the mail yesterday showing I was supposed to be here today. I've got a $60 payment now and I'll get paid Friday. And I'm supposed to pay $250, is that what?
Yes, you're supposed to pay $250 by today in order to purge yourself of contempt.
I just got the mail yesterday. I just moved out of what the home I was in. And I wasn't aware until yesterday, but I've got 60 now and I can pay the rest Friday when I get paid.
Okay.
She can make a payment this week.
She
Put her on the
have
queue
it
docket.
paid, you have to pay the 250 by close of business on Friday, or turn yourself into the Dare County Jail. Okay,
Thank you, Judge.
okay, thank you. I'll give you the benefit of the doubt that you didn't get the mail.
You got your feet in June.
Yes.
Yes,
ma'am.
please.
June the 27th.
Thank you, Judge.
Okay, Norris versus Norris.
Judge, Mr. Norris was held in contempt last month and given until today to pay, and he has paid. So just asking for a review date.
Arnold versus Arnold.
When was the review date?
September 19th.
Number 19. Arnold versus Arnold.
This is.
He was also given until yesterday to pay last month, to purge himself of contempt. He has not, so we're asking for an order of arrest.
Okay, how much is that?
He was ordered to pay $250.
Okay,
250 plus the one.
arrest and just put him in the Dare County Jail and purge himself of paying $250. It says $482. Has to pay $482 to purge himself.
I think it was 250 plus the first payment of the month or something.
It's 482, so they cleared $482. There you go. What's your last case, Thrasher versus Thrasher?
Yes, sir. And it is just a motion and order to intervene. The parties agreed in their custody paperwork to let child support go through us. So just an order to intervene.
Submit the order. Okay, thank you.
Thank you, Justice.
Yeah. Okay. Okay, well, it's 7 minutes until the civil docket is supposed to start.
Do you want me to go on for it until?
Sure. I'll call a case of, Mr. The highly technical move of pushing one button to get my thing on, and my staff lawyer didn't think I was capable of it. Usually I'm not, so. This is Commonwealth Kentucky versus Martha King. It's motion for entry of judgment, and Mr. Keith Upchurch is on the line, and they're just kind of giving up the ghost.
They are. We have no objection, Your Honor.
No objection to Ms. King keeping the money. She's
King
ready to withdraw.
blasted them on that, so
Okay.
that's fine.
That's good.
Thank you.
That's a good choice. Now, I guess you're gonna, was there an order submitted to Mr. Upchurch on that?
Yes, there was a judgment.
Next one is a motion for a trial date in Commonwealth Kentucky versus Carl Spears and others.
Your Honor, I may have messed up in my electronic filing of that. I tried to file that for the 27th of next month to give Mr. Judd a chance to communicate with his clients, and I may have messed up and got it put on this, Your Honor's current docket by mistake. My apologies if I did, but
the notice says the 27th day of June on it, so it was improperly put on by the clerk's office instead of you. So we just said over the 27th day of June, okay?
Thank you, Your Honor.
No problem. It's it finished you up?
Yes, it does, Your Honor. May I be excused?
Absolutely. A
Thank you.
motion for summary judgment filed by the Bank of Salina.
Good afternoon, Your Honor.
Hello.
Ben Crittenden, I represent the Bank of Salina. That's our motion.
Yeah, I've read this thing. I've been familiar with this thing several times over the last 6 years. And I read it again last night. And Mr. Cross, I really don't ever see how this was a power of attorney or attorney in fact sort of case in the first place, because nobody signed a document as an attorney in fact. You agree with that? Well, I mean, I don't want you to agree with, I don't want you to argue it. I just want you to ask me if I'm missing a document.
Well, we don't know.
Well, yes, you do know that nobody, well, let me finish, that nobody has signed it as an attorney in fact. Now, I don't think somebody can sign somebody else's name if they don't identify themselves as an attorney in fact, and it be valid.
Correct.
So that takes care of that. Now, the other thing, I couldn't figure out the $50,000 for a while. So somebody, allegedly the deceased individual, signed a $50,000 check on First and Farmers to the Bank of Salina. And then the Bank of Salina, the First and Farmers challenged it, but evidently under the Uniform Commercial Code didn't in a timely manner challenge it. So they were ordered to pay the $50,000 to the Bank of Salina. Am I going along all right?
That's correct. That's correct. But they had to go to federal court to do that.
Well, I know, they don't complicate it. I'm just following the time. Now, somebody, allegedly the deceased signed 4 checks of $12,500 each to the 4 children of the deceased. And the Bank of Salina claimed that they got on the telephone with someone, but they never did say that they knew the lady, they recognized her voice or anything like that. They said they asked certain qualifying questions of whoever answered the phone. And based upon that, because of what, and they did that beyond the responsibility that they had to make sure that the $12,500 checks were legitimate because of the large amount, which just happened to be the same amount totally that the $50,000 check was written on. Now, several of the parties have passed away, and I don't know whether there have been the appropriate papers filed here for substitution of parties.
Yeah, I address that, Your Honor.
Yeah, you could.
We believe that 2 parties that passed away were about as worthless dead as they were alive.
Well, don't say worthless, they
well,
just didn't have assets.
I'm sorry, Your Honor, but basically these people were picking the bones off this lady before she died, all 4 of them. There's only one of them that we think we could obtain judgment on, and that's the one we've moved for judgment against today and that's Tammy Sarmento, I believe her name is, in Indiana. And that is, so
Well, what did you,
no
I
revival on
thought
the
the
other.
motion for summary judgment was by the bank.
It is, but I filed a supplemental motion for that against Tammy.
Well, I didn't, I guess,
It's in there.
when did you file it yesterday?
No, it's been, that month ago.
Well, here's the thing about it is
We don't have any objection.
obviously an attorney in fact situation is not here. What you got is a factual situation of where those signatures are, correct? And, as I was reading the pleadings, did you ever deny the signatures?
Did we, as
Yeah.
the plaintiff, Your Honor, the signature.
I'm just
yes.
asking, okay,
Yeah.
I'm just asking, I didn't see that. So they denied the signatures and you've got two employees said that the signatures were correct. Is it down to 12,500 is what it's down to now?
The bank's position is that the signatures were authorized. There's no way for anybody at the bank to know with any degree of certainty if Mrs. Williams signed the checks or if she authorized somebody else to sign the checks or.
Listen,
He never told Keith Radford, did he?
every day, people pay or don't pay based upon signatures that's the reason you got a signature card. You take your signature card, you put it up here, you put your other card down there. And if they are, very similar or almost exact, I have a doubt. Maybe one of the attorney in facts did it, but the other signatures that are presented as exhibits seem to be paid by someone, signed by someone that's much more frail. Might have been a bad day that the individual signed. So you're willing to give up on the other three $12,500?
Your Honor, we want to.
Well, I mean, give me an answer.
Yes,
here.
yeah,
Okay.
yes.
All right. Okay. So you're giving up on them and you want the bank to pay 12,500?
No, I want Tammy to pay 12,500 and I want them to pay 37,500.
I got you.
And I think Tammy's collectible.
Well, you want the bank to pay all of it and then them collect, wouldn't that be, they'd be the ones that would collect the 12,500, wouldn't it? Then you'd rather have a judgment for the entire amount against
Oh,
the
I'd
bank?
rather have $50,000.
Yeah, I would
against them,
think
yeah.
so. I mean, that's what I'm mixed up about, why you're saying that you want them to pay 12,500. I'm easily confused.
And Your Honor, and I, Mr. Crittenden and their firm, they're correct. This thing's gone on too long, but Mr. Williams died, then we had the federal court case, and then Mr. Warren has just disappeared from the earth, and he was representing all of these Strongs. And I told him time and again to file a motion to withdraw, and to my knowledge, he never has. But I've gone ahead and noticed him and her on our summary judgment motion against Tammy, so, but it's been frustrating. He just quit the practice of law, apparently. Which I'm tempted
Some
to
days we all understand
into
that.
that.
So if you get the 12,500 against one person, you're willing to absolve the bank from that 12,500?
If they pay 37,500, I'd be pleased as punch. Yeah,
I'm sure.
yes.
Sure. You don't object to the 12,500 being against the,
Oh, no, Your Honor, he does have a summary judgment motion against one of the individuals and the bank doesn't have any.
okay, well, I'll enter summary judgment for 12,500. Now, the problem that you have, if you don't have any objection to that, there could be a finding because that signature wasn't valid. You might have that visit you again. Well, let's set a trial date. I just tell you, I don't think this, I think you're exactly right about the attorney in fact, all that sort of stuff. But I don't think that just calling somebody that you don't know and asking, maybe you shouldn't do anything. You still have an obligation to take a look at the signatures. And that's a factual situation. Should be do you have any expert witnesses that you're going to call?
If you'll-
Mr. Slider or somebody.
Stephen A. Slider, I presume, is dead.
No, I don't think so.
Really?
No, the expert witnesses on signatures
I
never
used him
died.
35 years ago, and he was an old man then.
Yeah.
But no, we will be bringing someone in, so if you set it out a little way. That would be
Well, I
great.
don't want to sit out a little ways. You know, these people deserve resolution on that. Okay, you got your calendar there with you?
You know what they say, work tends to expand or contract to fulfill the time allotted for its completion. So that's Parkinson's law, Tracy, so that is.
Yeah. Sometime in, how about July 16th?
That's a date of near impossibility, Your Honor. I'm sorry.
Okay. Well, let's find another day.
That's, it'd be a long thing, it would be, but yeah. I can't imagine we would ask for one, but yeah. Well, we're just discussing, Your Honor, we think a bench trial would probably work. Would make it a lot easier to handle this.
Okay. Okay. Well, if it's a bench trial, we can do it on Wednesdays too. What about June the 19th? Is that too soon?
It's, Your Honor, I think that's really.
Okay, it's too soon. Okay.
I've got.
Okay, it's too soon. You don't have to explain why it's too soon. What about July the 17th?
Say the 7th.
17th.
17th.
You couldn't do it on the 16th.
I'm good. I'm good on.
July
17th.
17th. Okay.
I'll draft an order, Your Honor.
Okay, wait a second. Now, you said you're gonna call a witness. Okay, and is this gonna be an expert witness by?
Your Honor, I know there's an expert available in Cookville, which I think we'll be using on handwriting.
Well, you know, you need to give the other side sufficient time to see if they want to obtain an expert. So what's a reasonable time for you to determine?
I'll pin her down the next 14 days, 10 days.
10 days, okay, 10 days for notice of expert witness, and then if you need additional time to get an expert witness, and you need to get the report to them in a reasonable time thereafter. What about the report by mid-June?
That's fine, that's Your Honor. I expect our position is gonna be that, you know, the signature was authorized by Ms. Williams under the applicable provisions of the Article 3 of the UCC, and whether she signed it or not. And so I would expect that we would probably just have the two witnesses who were the bank employees at the time who made those phone calls come in.
Can I call David Leach as witness?
Well, I've had him before as a witness here.
He was good.
Is he still alive?
I don't know, people we went to school long ago.
Law professors. What provision of your Uniform Commercial Code do you say that you can have authorization to sign without any?
Article 3. We filed a reply memorandum this morning, Your Honor. I apologize for the late time of that.
Can I get my report to him 30 days before trial? Is that okay? It's 17th next week.
Well, if it's okay with them, you know, if they're not gonna get an expert anyway, it doesn't matter, you know. So if you file that, I'll find it today. I was the first person to invoke the Uniform Commercial Code in Cumberland Circuit Court back in the day, and I was informed by the then sitting judge, Judge Carter, James C. Carter Jr., that it didn't apply in Cumberland Circuit Court. That they were going by the old Kentucky business law. I mean,
I'm confident that's what he said.
and he did say that, you know, so.
What about the Court of Appeals?
Well, they didn't get a chance to. Brown, Todd, and Haber was on the other side when I called Professor Leaps, and after he testified, we were able to settle. Okay, thank y'all very much.
Thank you.
Yeah. Okay, LaCosta Smith Carver versus Brett Carver.
Good afternoon, Your Honor.
Hello. Now, the motion that you filed, Mr. Davenport, was about the violation of the previously entered order concerning keeping the unnamed infant child, or the child who I will not name now since it's a public hearing, away from any hunting activity, an allegation that hunting activity, the couple came and stayed in the house there.
Correct.
When the child was present. You
We'll
have
stipulate that's correct, Your Honor.
okay, now you have, what was your motion about?
Well, we've got a motion for contempt and attorney's fees.
Well, about what? I read it, but I can't.
Regarding depriving Brett of the child.
Yeah.
And Your Honor, before we get really into this, I know we've got a hearing set with Mr. Somm on the 5th day of June on some matters, so.
What matters are those set for?
Well, I guess we're trying to get to the point where we can have a final hearing on this case, but
Well, I might, you know, since this is drug on, Mr. Somm might not have to look at this thing. I might just do it myself.
It'll be fine, Your Honor.
You know, because these people need some resolution of things so they can take it up if either one of them don't agree to it. So the reason I'm asking is, how long do you think it will take the hearing? I mean, are you in agreement on anything? At some juncture, I'd like to do a checklist to see what we aren't in agreement on.
Your Honor, we've not been able to agree on whether or not Burkesville's in the central time zone. It's been that bad.
Well, that could change at any time, so an agreement on that could just be temporary.
I would say, in contrary to what Mr. Cross has said, the order that we're here about today actually was agreed upon.
Yeah, I understand. We're gonna get to that in a minute.
Yeah, and the hearing, I don't know what hearing we have set for June 5th, unless it's the hearing I got faxed to me about 20 minutes ago. I haven't even read it. So I don't know what that's
That hearing
about.
is canceled in front of the commissioner. Okay, so you don't have to worry
Your Honor,
about that.
we have
Let's
no
set a trial,
objection
let's set a trial date.
I think that's the best way.
Well, here's what I figured is when you got a case that's this contentious between the parties and the commissioner makes a finding, and I'm gonna have to see it all over again anyway, so we might as well take one bite out of the apple rather than two.
Yes,
So if y'all got your calendars here and tell me if discovery's finished, and we'll get back to your motion.
Yes, sir. The discovery, I will speak to that, Your Honor. I don't want to get into details that would be improper, but after we got, Mr. Carver's discovery responses in early March, we did, my client and I went through those. We made an attempt to settle yesterday, just yesterday. We did make an offer. If that's not acceptable, I've asked for dates for depositions for Mr. Carver. So that is something that I will want to do between now and Your Honor's trial date. I'll just tell you.
I won't set a trial date until the deposition is finished then, but knowing that you were here previously, it doesn't take me long to set a trial
Yes,
date here.
I know that.
And the reason we don't set a trial, have that is because I don't set trial dates and clog things up until people, they're ready for trial. Okay, so, you think, have y'all tried mediation in this thing?
I just fear we're as far as the east is from the west, seriously. And we did receive Mr. Davenport's settlement proposal, and I appreciate that, but candidly, I I don't think he and I are looking at the same case.
Okay, well, we all put it in somebody else's hands and that's the way if people don't want to reach agreement, put it in somebody else's hands. Okay, how much time do you need? Are they as far as finishing your depositions and things like that?
Mr. Carver's deposition will take probably the better part of a day. That is unusual in a divorce case.
Okay, well, I'll tell you what we need to do. Y'all got your calendars here.
Yes,
While
sir.
I'm here, present, it'd be a good time to set that deposition.
I agree, Your Honor, that's fine.
So Mr. Cross, do you want to shoot me dates or you want me to shoot you dates?
Well, you just start firing them at me. June's pretty busy, but believe you me, we all want to get this thing done.
How's June 27th look?
It is, I'll be with this gentleman here that day. I'm sorry.
Okay.
Yeah, that's our rule day, I guess.
How about July the 18th?
I could do July the 18th. Can you do? We can do the 18th.
No, that's here. But
This is just for a deposition. we're
It's,
talking.
it's here, but they can,
Yeah.
y'all want to use the facilities here, or you want to use somebody's office?
I just shouldn't come here.
That's fine with
Yeah, well,
me.
we'll make
It's a
available,
good facility.
we'll make available the courtroom downstairs on that day. We'll make sure we reserve it. And the courtroom downstairs is small, but it has good side rooms that you can go out for conferences and that sort of thing.
And I'm going to make a suggestion, Mr. Davenport. We take Brett's, let's notice Lacosta's for the same day. If Brett's goes on and on, we don't have time to do hers, then we'll reschedule hers. How's that?
That's reasonable to me.
Okay, now, okay. You'll make your own provision for the court
I
report.
will, Your Honor. And I'll have my office confirmed with the courthouse here, the ring.
Okay, is there anything else? Oh, let's get back to your thing now. How old is the child? 14 and there were reasons, there's special reasons.
Approaching that regard, Mr. Davenport, and I briefly.
Well, you can if you'd like.
Yeah, confidence.
Well, the clients have a right to be here
Well,
too.
of course they do. Of course they do.
I don't know how to mute it now. We can get something up here every day.
No, it's not on. It's not on.
And Mr. Cross, and I'm assuming you'll all remand and whatever that notice for. Yeah.
Okay, Gilbert versus Gilbert.
Judge, we have an agreement between the parties right before the hearing today.
Well, congratulations. Are the parties here? Or?
No, the parties are not here. I'm gonna be tendering this agreement shortly, but everyone was sufficiently pleased.
Okay, that'd be good. You submit it over here. Okay, Thrasher versus Thrasher.
Good afternoon, Your Honor.
Hello.
Your Honor, this is my motion to establish custody. These parties had a domestic violence case over in Hardin County, but my client relocated to Cumberland County in February and then subsequently filed this action. I'll set out our proposal here since it's not listed in my motion. She is proposing on a temporary basis. And
What did the
potentially-
domestic violence order?
Yes,
DVO, what kind of visitation did it establish?
Your Honor, in that they suggested that the parties, ordered that the parties follow the Hardin Family Court schedule, which I have a copy of here.
You have a copy of that also?
Yes, sir.
Okay.
It is a somewhat more complex schedule for a
Well,
layperson.
they're much more intelligent up there and than I am here and more complex, so I understand that.
Your Honor, no.
If the legislature would give us a family court judge down here, maybe they could bone up on what the law is. You know?
Yes, so I
Are
think
you
that-
willing to go by that order?
Your Honor, with this, the problem is that the respondent, I think, is misinterpreting it. So what we are
Okay,
proposing.
well, let's read the portion that he's misinterpreted. We might enlighten him on. Okay.
Yes, Your Honor. So he sent a proposal which lists 8 additional weeks, which is part of Schedule 1 is what he said would apply. It lays out a schedule if the parties
But
live.
speak in English here so we can understand. What did he propose that's wrong?
So among other things that we have an issue with, he has proposed that the parties, that he gets an additional 8 weeks during the year.
Okay, what does that order say he's supposed to get?
So Section 2 is what applies because my client is
What
not.
is in Section 2?
Yes, Section 2 is if the parties do not live in counties next to each other essentially.
Yeah.
Which is the case now.
Cause she moved.
Yes, because she moved as a result of the domestic violence because her family was down here. His is in Washington. So what he has proposed that we object to in Section 2, so first of all, part of what he tried to follow is in Section 1, which really doesn't apply to the parties because they don't live next to each other. In Section 2, for the summer vacation, he's proposed that he gets 3 weeks in a row, essentially, with a child who's 8 months old. That section.
Little boy, little girl.
Little boy, Your Honor. So that section indicates that the party shall get 5 weeks during the summer. And in his summer schedule, he included a week in November, which by my mark is not the summer. What we are proposing is something more regular, something easier perhaps for a layperson to understand, which is just every other weekend, and then the parties alternate week to week throughout the summer, starting when school break has begun. We would propose a schedule that starts with the parties exchanging the child next Monday. With holidays, we're just asking for a standard
How much
holiday
time in the
split.
summer are you talking about?
It would be more than the 5 weeks.
How
I
much time?
Your Honor, it's week to week, starting when school lets out. So school has let out, my understanding is now. So it would be a total of at least 1, 2, 3, 4, 5, 6. It looks like 7 weeks, Your Honor, I'd say.
And during the school year, it would be every other weekend plus what?
Every other weekend, and then there's also issues of holidays and breaks, which we would propose they follow the standard schedule with.
Is that acceptable to you?
I don't agree to that, as of right now. I spoke with an attorney who told me that I
I
was.
don't care what your attorney told you. If you want an attorney, you need to bring an attorney with you. I'll tell you what a judge is gonna tell you. that what she's proposing is contrary to the Kentucky Revised Statute unless there are reasons of finding that you get less than 50-50, which that's the non-contiguous county and all those other sort of things I guess you're talking about. Is that right?
Yes, I understand, Your Honor, and we can address that, and I'm prepared to address that, and I think.
Why
there's
don't you have an
reasons.
attorney here?
I can't afford one.
Well, should go to Apple Red.
I was
Your Honor,
told,
there is a conflict.
Oh, I know, but that's the one thing that I got against Apple Red, is y'all ought to have conflict attorneys. The first person that gets to you have an attorney and the other person's left without one. And y'all are good attorneys, every one of you on this family stuff, and you just grind them. So what chance does he have?
Your Honor, we proposed a comparable schedule, at least for right now, as to what's already in place. I'm just asking for something a little more understandable for him and for my
Well,
client.
I think he can he seems like to me he's capable of understanding. And one thing he doesn't understand is he's not gonna let you get a proposal that's contrary unless we have a hearing and some findings. Now, the domestic violence order, I mean, was she injured or was there threats or what was the deal?
Your Honor, part of what she had alleged was she had been held captive, essentially tied up and beaten periodically. So pretty serious allegations, but nonetheless, the court ordered what it ordered. The child has not been harmed. It's my understanding that the drafter has completed a mental health assessment and a domestic violence assessment. Entry of a CBO by itself overcomes the presumption of being unfair.
What do you do for a living?
Your Honor, I do contract work with Gooder LLC, which is a digital marketing company. And I do Uber Eats as well.
Well, there are lawyers here in town that are not as expensive as the lawyers that you probably have up in Hardin County. I'm gonna suggest that you get a list of local lawyers that do domestic law and you get a lawyer come here and let the lawyer negotiate that. We'll set a hearing and you won't have to wait till a rule day, counselor.
Yes,
to
Your
do that. I'll set up a hearing on this sort of thing. I would suggest, if you sit down person to person and try to negotiate something with him
Yes, sure.
and it didn't work.
It did not work at this point. It may be the case that the parties.
Well, I mean, I wouldn't have agreed with you either if I'd been representing what you offered him.
I understand.
Maybe you could go back there in the room before I leave here. Well, it's too late today, but what kind of visitation? He's operating under the DVO right now, correct?
Yes, under the DVO, Your Honor, it had said to abide by the Hardin.
Yeah, just tell me what it is.
So that is on section 2, periodic parenting time, which
Tell me what it is.
it doesn't actually say what periodic parenting time is.
So you don't have anything in place?
It just says telephonic 1 hour, 2 times per week. They've been doing every other weekend though. So she's not trying to withhold the child.
Well, I'll leave the every other weekend in place, but
Yes.
what kind of provisions you have for the child for if you need a week?
He has a crib, a playpen.
Are you live by yourself?
Yes, sir.
Have
Yes,
you
sir.
taken parenting classes where you know how to take care of a baby and that sort of thing?
Yes, sir, and I have copies of that if you'd like to see.
No, I'm just asking. I have no reason to deny that you have. I just want to make sure. This is your first child?
Yes, Your Honor.
Yeah, well. If I was renting you a houseboat, I wouldn't want you to take off until somebody showed you how to steer it. So I just want to make sure that you got it going on. Okay, I want you between now and when you come back here or give me a date, I want you to provide him a week. I want you to give him a week. And I guess you don't want him to take the child out of state. When you put that in the provision, you shall not take the child out of state.
That's right.
Give him a week. And then we'll do every other weekend and give him the week on one of the week, so it doesn't take one of his weekends. You understand what I'm saying?
I believe so, Your Honor.
Okay, now that'll give you all time for you to get a lawyer and you appear, if you haven't reached an agreement, I'd get a lawyer as soon as I could. And if you hadn't reached an agreement, y'all be back here in court on June the 27th.
Yes, sir.
Okay,
Yes, Your Honor.
now,
The last matter
now-
of business.
a court has certain obligation to make sure everybody's treated fairly and protected, but you're on your own. If you come back here next week and she's gonna grind you, you understand what I'm saying? Okay, well, thank you all very
Your
much.
Honor, the last matter, if I may, there is a matter, if we had requested a hair follicle in your analysis drug screening, my client's prepared to pay for those. I believe Mr.
Has there
Thrasher,
been any proof that he's drug addicted or anything?
she has seen him use drugs in the past, yes.
Do
Your
I?
Honor. She has seen him use drugs in the
What
past,
kind of
including
drugs?
marijuana, some she.
Well, I'm gonna
cannot
tell you
identify.
what, I'm not gonna order a marijuana test because it's legal in most states. And I've never seen anybody smoke any marijuana and beat their child or their
She's
wife.
also seen him do
She want a
other
liquor
drugs.
test, I give her one of these. A lot of people drink some liquor and rough up there.
They do, Your Honor, and that's
Hey,
certainly an issue, but she's.
Next
seen
time
the
you,
drugs.
next time you come here, you be ready for a drug test if you come here.
Yes, Your Honor.
Now, marijuana, if you used it this last week, won't be out of your system till then. But if you come back down here and I order a drug test and I don't want any marijuana in it, it's illegal.
Yes, Your Honor.
I don't want any marijuana, but if you got even any marijuana, you just don't come back down here, you understand what I'm saying?
Yes, Your Honor.
So I understand what you're saying, but I don't think that
I
the
understand.
fact that she saw him smoke some marijuana in the past ought to make him do a drug follicle
I
test.
understand, Your Honor. She's
Okay.
got more concerns than marijuana.
Thank you very much.
Thank you, Your Honor. That
Yeah.
concludes my business. May I
Yeah.
excuse?
Have a nice day.
You too, Your Honor. Thank you.
Yeah. You can stop at the clerk's office downstairs, young man. This lady right over here is a local attorney. She's about to go on maternity leave, but she can go with you and give you a list of attorneys in the area that do domestic. Will you do that?
Yes.
I mean, I know she can't take your case, the reason that I'm suggesting that she talk to you. Brewington versus Brewington. Hello. Hello, hello.
Mike Harris, appearing for this cast on behalf of Ms. Brewington.
Your Honor, we've talked some in this case. I think Ms. Capps has some motions pending. She's out of the office. And I've talked with opposing counsel. I think we're looking for a temporary status quo order. If they have no objection, exclusive use of the home by my client where she is now. We need to see about getting a hearing date. And depending on when that is.
Well, what are the issues that we got? I saw the issues here about joint custody. Of course, that's to be presumed unless you got reasons not to. And then child support, those calculations are made with the adjustments of joint if it's not. And timeshare schedule. That won't, unless you prove the joint's not there. And then temporary maintenance. Tell me what their backgrounds are and what they do. What does your client do for a living?
These machines, Your Honor, self-employed, but the main issue, Your Honor.
Get behind the microphone if you don't care.
The main issue, Your Honor, is lack of notice. Ms. Capps filed this electronically Wednesday of last week along with the motions. My client was not served until Monday of this week.
We're not gonna make any permanent decisions today. Don't worry about it.
We're in a position where we can stipulate that he's allowed to have exclusive use of the marital residence. That's fine until the next hearing, please.
Okay, that'd be good. That's a
And
start.
He just wants to.
How many children involved?
Three.
3 children involved. How old are they?
16, 14, and 8.
Well, there's no little bitty children involved. Is your shop next to your house? It's always is.
He's moved out though, Your Honor. He got his own trailer and his own, a different shop area.
Yeah.
And has moved his equipment there. So we just want use of his equipment. So we
Yeah,
can continue.
that won't
working.
be any problem.
That's not any problem, Your Honor. We would request, my client advises that has been going off, leaving the lights on and leaving compressors and other things running that will run up the electric bill, and the electric bill comes to her at the house. So she would just ask that if
That
that's
won't be a
happening.
problem. He'll,
Proposes to taking all that out anyway.
okay, that won't be a problem. Put
He
it
just
there.
doesn't want to keep coming back down there to work every day to that shop.
Yeah. Well, what he needs to do is anything he removes out of there or has removed out of there, he just needs to make a list, give it to you, and he can serve it on council on the other side, so there won't be any problem about that, so. He needs to give a list of everything he has taken out of there, and as he takes other additional things, he gives y'all a list of that.
Thank you, Your Honor.
Okay, is there anything else?
Do you
And what
want
about
that?
the visitation between now and then?
What's going on with the visitation?
He's been coming when he gets time and then, every other weekend. During the week, he just comes.
So that up to this point, the visitation is amicable as it can be. In other words, y'all are getting along on that as far as parenting is concerned.
I just would like notice, when he wants to come and see
Okay,
him
well,
during
let's
the
do
week.
that. Let's just say that you need to give her maybe a two hours notice. Is that enough?
Yes.
2 hours notice before you come over there, just to keep any problems from arising. And if y'all continue to work on that until we get something final, that's the best way to do because of different people. Do you work, ma'am?
I start a new job June 3rd.
Well, good. So then there's gonna be the situation, both of you have to work around your schedules, okay?
Which
Okay,
weekends is he getting? Is he getting this coming?
This
weekend?
coming weekend is his weekend.
Okay,
okay.
all right. So you want me to put together an order and send it to opposing counsel for approval?
That'd be
on-
good, but let's don't get
That's
too detailed in the order as far as the visitation. It seems to be, just put the parties seem to be in accord about every other weekend visitation and other times with 2 hours notice. And let's see if they can work through that without us lawyering them up on it.
Right, just say something like the parties are currently working out visitation.
Right, that'd be good.
And then with the main things are the status quo and the exclusive
Yeah.
use of the
Now, who's
house.
paying the utility bills at the marital residence? Okay, well, how much are they running?
Right now, it's air conditioner is running, so.
Well, I mean, I don't care what, I'm not, are you using the mixer very much? I don't,
$100 a day.
he needs to be paying something on utility bills and stuff so we get this
I'm
going.
gonna get paid.
In our motion, he's already provided her just in the past few weeks with 100% of their tax refund. about
How much is
$6,000
that?
or $7,000.
Okay, have you gotten, have you gotten the $6,000 or $7,000 from the tax refund from?
Yes, we had a verbal agreement in February.
Well, I don't care why you had it. It's good. You can keep it. So I'm not going to order anything temporary until you hit, that'll keep you, tide you over till we make something else.
Plus half the proceeds from the sale of cattle.
Well,
So it's
that's
about
good.
11,000.
Well, we'll just, she got somebody to operate till she gets her job going, so I won't worry about that. Okay, is there anything else?
I think that's.
Well, I would suggest
Oh,
that,
except a hearing date.
Yes.
well, we're gonna have a hearing date, y'all. I'm sure y'all gonna agree to all this stuff. So we won't,
You're not gonna set a hearing date at this time?
well, I can, but it appears to me that, have you exchanged discovery yet?
It just got filed.
Well, I mean, I would think it would be good to sit.
So you're saying for either council to file for a hearing date?
Yeah, they need to exchange
Negotiations
discovery.
break down.
Yeah, they need to exchange discovery. And after discovery, they need to be a legitimate effort to reach an agreement. And I can set a hearing date in short order because I don't clog it up by setting hearing dates that aren't ready.
Right.
So I can give you a hearing date probably within 30 days. You get to that point, okay?
I think
Very
a
good,
good
John.
chance it will come to agreement.
Okay, I think so too. I mean, it's better, I mean, you got a couple of reasonably billing lawyers here. Now that Ms. Cap's now, if Mr. Harris was there, he charges more than Ms. Cap does, I'm sure.
I don't know, y'all. I don't feel like I know anything anymore.
Okay, well, and I know this is a difficult time for both of you. Even when you need to get a divorce, it's a hurtful thing when you've trusted somebody and you lose the trust and you have to separate. But what you need to do is try to be as logical as you can and go down through for the benefit of the children. I want to commend you for it. At this juncture, it appears that you're setting a good example as far as the children knowing that both of you love them and that you want to visit them and that sort of thing. And it'll make it easier as we go through this, that's not the way. Okay, well, thank y'all very much.
Thank you.
Y'all have a good afternoon.
Excuse
Yeah. Now we have a matter set at 2:00, which is the extension of a DVO. Is there anyone here on that? You have that file. I have a separate docket for that. DVO docket. It's Finley versus Finley, and it was to expire on 5/27/24. Would you like that extended?
Please.
Could you, is there any particular reason that you have? Are you still in fear?
Yes, he's in and out of Eastern State quite often. And
Yeah.
just
Okay, well,
To me,
what's the
not
period
feeling
I can
settled.
extend it to? 3 years, I'll extend it for 3 years.
Okay.
And then I understand you want some change.
The address changes. I'm no longer at 126 South High Street.
Okay, well, you just provide
Okay.
to the clerk's office, so we
Okay.
won't be on the record as to
Okay.
where you are. And is that the only address that needs to be changed?
I'm gonna take Tasty Foods off. I no longer work there.
Okay,
I'm gonna leave Mama's on. Caleb is on Mama's property, but he has a different address. than he
okay,
was-
so
his ad-
you give those, your address and his address on your mother's property, okay?
All right,
Okay, thank you very much.
thank you.
You have a good day.
I'm sorry, Kirsty. Okay, she can be-
Okay, that concludes the business of the Cumberland Circuit Court, and so we're adjourned.